Okay, I think we're ready. Looks like that's all working. Good morning, everyone. Happy Friday.
Good morning.
We are a two-headed court today. We've got a few Judge Ingram cases and then some Judge McBurney cases. And I guess I want to take stock of who's here and who's ready, and we'll get going. Some of the inmate elevators aren't working, so that has slowed things down, but I think we only have one person in custody. And that's Mr. Gomez. He's not here yet, but Ms. Cabrera's not here yet. We've got Ms. Scott. I understand that's going to be a non-negotiated plea. Where's Ms. Scott? She's right here. Great. Okay, so she's ready to go. And Mr. Benjamin, I know his lawyer. I see his lawyer online. Good morning, Mr. Bikwe. How are you, sir?
I'm good, Judge. I appreciate the call. I lost another family member this past weekend, Your Honor.
I'm so sorry. I'm sorry to hear that. I appreciate you taking time to be with us. Any idea where Mr. Benjamin is?
He's on his way here, Judge. He told me he's going to be here in a few minutes. I spoke to him earlier.
Okay, he's on his way to your office or to the courtroom?
To my office, Your Honor.
Okay. And Mr. Abikwe, is this going to be a plea today?
No, Your Honor.
Okay. Well, I guess we'll have a conversation about that once your client gets there. Thank you.
Thank you.
And again, I'm sorry for your family's loss.
Thank you, Judge.
And then we had an add-on in the form of Javon Redmond. And he is online. I don't see his lawyer anywhere. I do see Ms. Dilligard online. Good morning, Ms. Dilligard.
Good morning, Judge.
Is this a plea?
Yes, Judge. And I spoke with counsel yesterday, so I am expecting her to appear.
Okay, great. Well, once she gets here, we can move forward with that. And then we have a couple of Mitchells. We have a Juan Mitchell. Juan Mitchell is here, and your lawyer's here. Hello, Ms. Lake. Good morning. And who's the prosecutor?
That will be me, Your Honor, A.K. Reed, and we expect that to be a negotiated plea.
Okay. And then we have a Keith Mitchell, also Ms. Lake's client, and he is online.
Good evening.
There he is.
It is Washington, State.
Great. And negotiated plea also?
Yes, sir.
Okay. And then I heard through the grapevine that Mr. Jintao is a plea now also. And it looks like he is on, and that would be Ms. Clark and Ms. Wood's case.
Yes, sir.
Okay. Good morning. So my thought is we start with Jintao so that the person who has 4 remaining cases on the trial calendar can go get ready for those.
Yes, sir. There's only one minor detail that we're still working out regarding whether this is actually a registry offense. So I'm just looking at the statute right now.
Okay. Do you want us to do a different plea first while you're doing that? All right. Let's see. Can't do Gomez. We could do Scott. Are you? You want to wait on Scott? Okay. Then, because we don't have Mr. Benjamin yet, why don't we turn to one of the Ingram cases? Ms. Lake, which one would you like to do first?
I know, court's pleasure, Judge. We're ready on both.
Okay. Well, why don't we do, since Juan Mitchell is here, Mr. Mitchell, why don't you come on up to the podium with your lawyer, please? And how are we doing this with court reporters? Is my court reporter going to take this down? Is that the plan? Okay, great. She's here. So I'll get Mr. Reed up there.
Okay.
I think we added that screen yet, so let's add that. It is. There we go. Okay. Good morning, Ms. Rivers.
Good morning.
You ready to go?
Yes, Judge, I'm ready.
Great. So we are going to start with 24 SC 001780. It's State versus Juan Mitchell. Mr. Mitchell is here in court with his lawyer, Ms. Lake. Mr. Reed is the prosecutor. Mr. Mitchell, in just a moment, Mr. Reed's going to put you under oath. Once you're under oath, you'll need to answer all of his questions and mine. I'll have a few as well. Need to answer those questions truthfully and completely. It's important that you let me know if you ever have a question. If someone says something that doesn't make sense or is going differently than what Ms. Lake told you, call a timeout and you and Ms. Lake can talk, or you can ask me what's going on, but I won't know that you're confused about something if you don't let me know. Will you do that?
Yes, sir.
Okay, when you're ready, Mr. Reed.
Yes, Your Honor. And do you prefer me to give the factual basis up front, or do you want me to do the questions first?
I prefer that you do it in whatever way you want. I will follow whether the factual basis comes first or later, whatever your norm is.
All right, thank you. Your Honor, this is indictment number 24 SC 001780. Charges of aggravated assault, aggravated battery, possession of firearm during commission, and the state is going to submit a null pros for count number 4, possession of firearm by a felon. So that leaves us with 3 charges, Your Honor.
Okay.
Factual basis here, this is June 22nd, 2022. Officers of the police department responded to location, a gas station in Fulton County regarding a man shot. They did locate the victim, Mr. Christopher Philpott, who was laying on the ground with a injury to his leg. He was taken to Grady Hospital and he was able to get surgery to save his leg. The victim stated to the officer and the detective at the hospital that this was an argument, that he did not know the name of the defendant, of the suspect, but he would later be identified as this defendant, Juan Mitchell, and that in a few days prior there had been, he had attempted to work at a car wash in the neighborhood that was run in part by a mother and son, and he stated that he went to offer some help, and he was confronted by the son, and there was some words exchanged. There was kind of the flashing of a gun, but nothing really, no violence went from that. And then that on the present incident, a few days later, June 22nd, Mr. Philpott was leaving the gas station and had witnessed this defendant, who he identified as the person he had gotten in an argument with, as the shooter, and that the shooter had fired shots at Mr. Philpott, striking him in the leg. The way that the defendant was identified is the detective was given a physical description by the victim, including some, the fact that he was bald, male, had some tattoos, and a officer, the detective ran some, did some investigation into names of people associated with that car wash, saw that this defendant matched the description given by the victim. Subsequently, the detective did a photo lineup, and the victim picked the defendant out of the lineup. This is a product of extensive negotiations as well as efforts by the state, including investigation and speaking with the victim. As a result, the state has agreed to a sentence. He spent about 90 days in custody, Your Honor. 10 to serve 90 days on the aggravated assault, 10 to serve 10 to serve 90 days, balance probated on the aggravated assault, and concurrently would run 10 to serve 90 days, balance probated on the aggravated battery, possession of firearm during commission of a felony, 5 years consecutive suspended, as well as the state will move for a null pros of possession of firearm by a felon. May I proceed, Your Honor, with the questions?
Sure. Why are you dismissing count 4? Is he not a felon
Not
or?
a felon.
Okay.
We have determined that, in fact, from the investigation that he's not a felon.
Okay, that's a good reason to dismiss it.
Yeah. Mr. Mitchell, please raise your right hand. You swear and affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
All right, you can lower your hand. Please state your name.
My name is Warren Anthony Mitchell Jr.
Are you the Juan Mitchell listed in this indictment?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or taking any medicine that affects your ability to understand these
No,
procedures?
sir.
Is there a medicine you normally take you've not been given today that would affect the ability to understand this procedure?
No, sir.
How old are you?
I'm 35.
And how far did you get in school?
11th grade.
All right, are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you're charged with following offenses, aggravated assault, a maximum penalty of 20 years, a minimum penalty of 1 year, maximum penalty of 20 years confinement, as well as aggravated battery, minimum of 1 year, maximum of 20 years confinement, as well as possession of firearm during commission of a felony with a 5-year consecutive sentence. And those are the maximums you could be facing. Do you understand that?
Yes, sir.
And do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
Do you understand if you plead not guilty or remain silent, you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Attorney Lake, about all the facts and circumstances known to you regarding the charges in this indictment, including potential defenses?
Yes, sir.
Do you need any more time to discuss the case with Attorney Lake?
No,
Are
sir.
you satisfied with her services?
Yes, sir.
Mr. Mitchell, do you understand that this is a negotiated plea of guilty, which means the state and the defense are making the joint recommendation to the court that I read earlier,
Yes, sir.
negotiated of the 10 served 90 days?
Yes, sir.
Do you understand that the court does not have to accept that recommendation and can sentence you to the max on each charge, run those sentences consecutively? So you'd be looking at 20 years. They would merge the first 2 counts plus 5 years by felon during commission. You could be facing 25 years. Do you understand that?
Yes, sir.
But do you understand that if the court orders a sentence that differs from the negotiated plea, you have the right to withdraw your plea?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
I didn't get that. I didn't get
So
that.
if you're subsequently arrested and charged with something, that this conviction could be used to have a greater sentence on a future conviction?
If you get in trouble again, a judge is likely going to look at this conviction and say, you got off pretty easy for shooting someone in the leg. You're not going to get off so easy next time. Some judge might make your next sentence all the more severe because you've already pled guilty to shooting someone. Does that make sense?
It makes sense. Can I speak to my lawyer?
Sure.
Thank you, Judge.
All right, we good?
Yes, sir.
Do you understand if you're currently on probation or parole? I don't believe you are, but it could be revoked based on you entering a guilty plea today.
Yes, sir. I know. I'm not.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation, and that doing so could result in your probation being revoked and having to serve that remaining 10 years in custody?
Yes, sir.
You understand you're not allowed to possess or use a firearm while on probation?
Yes, sir.
You understand after pleading guilty to a felony, you cannot use, receive, possess, or transport a firearm, and that doing so carries between 1 to 10 years in jail?
Yes, sir.
And do you understand if you use a firearm in a crime, you could be sentenced to, I guess it would be 5 to 15 years in prison, and actually it would be a second possession during, so it'd be 10 years mandatory, and that would run consecutive to any sentence on the underlying crime?
Yes, sir.
And are you a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to bear arms, and the ability to obtain employment. Do you understand that?
Yes, sir.
Do you understand when you enter a guilty plea, you waive any and all defenses, including mental health defenses?
Yes, sir.
Do you understand you waive other legal and constitutional rights when you plead guilty, including the following: right to trial by jury, right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel at trial, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, the right to present evidence and testify on your own behalf, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Understanding all the rights that I've just read, how do you still wish to waive your rights and plead guilty?
So yes.
So it's just saying.
Hold on, before you go, tell me what your concern is.
I'm taking the plea on because I don't want to go to trial, but I didn't hurt nobody. I'm just.
Okay, well, there'll be a chance for Ms. Lake and for you to talk a little bit about your perspective. But it sounds like perhaps you are entering what we call an Alford plea, where a defendant says, I don't agree with what the state said happened, but I don't want to run the risk of going to trial. And I think it's in my best interest, meaning Mr. Mitchell's best interest, to take this plea. Does that describe your situation?
Yes, sir.
Okay, I can accept that kind of plea, and I'll make sure that I hear from your lawyer and maybe even you about your perspective on the facts. It's going to be important for me to hear that, because I'm a little puzzled as to why the state would go along with a plea like this if someone got shot. But I will listen to both sides.
Sir.
Okay.
Your Honor, Mr. Mitchell, on 24 SC 001-780, how do you plead?
You can say guilty under Alford.
Guilty on the offer.
And is it, so does that mean you're pleading guilty because you decided it is in your best interest to do so?
Yes, sir. I don't want to go to trial.
Are you aware that even if you do not admit guilt, this guilty plea places you in the same position as if you were convicted by a jury at a trial?
I didn't get that, sir.
So even though you're pleading under Alford, that on your criminal record and everything, it will still place you in the same position as if you had gone to trial and lost.
Okay, I understand.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
You understand you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand unless she withdraws, Attorney Lake will represent you until the end of the current term of court or 30 days from today, whichever is later.
Yes, sir.
Do you understand you have only 30 days from today to file a direct appeal of this conviction?
Yes, sir.
You understand you have only 4 years from today to file a habeas corpus petition challenging any constitutional issues from this guilty plea?
Yes, sir.
You understand you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, sir.
You understand any of the filings we just discussed must be filed by your counsel unless you're representing yourself?
Yes, sir.
All the questions I have, Your Honor.
All right. Don't think we have anyone from pretrial services. Ms. Simpson, do you have any criminal history information on Mr. Mitchell?
Yes, Judge. He has $13 cycles. Last arrest.
But it doesn't look like he was ever on felony probation.
No, Judge, he only had one case where he led a first offender and completed.
Okay. Got it. Okay, thank you. Ms. Lake.
Thank you, Judge. Your Honor, we do ask you to accept the plea as negotiated. We ask you to accept it as an Alford plea, and I'll elaborate on that, Judge. So what Christopher Philpott tells the police while he's in the hospital with this leg injury is that the person that shot him is the son of the woman who owns the car wash. He describes somebody pulling up to the gas station where he is at the time that he shot and shooting him from a red sedan. He also describes that a few days before, he had gotten into an argument with the son of the car wash owner at the car wash, not really explained what the argument was about, other than that Mr. Philpott was homeless and looking for work, trying to wash cars, and Mr. Mitchell chased him away, essentially. Also not explained why on earth Mr. Mitchell would want to sit in a red sedan and wait for Mr. Philpott in front of a gas station to shoot him a couple of days later. But the identification was of Mr. Mitchell. It was of the car wash owner's son. But the person who shot Mr. Mitchell, we believe, the person who shot Mr. Philpott was not Mr. Mitchell. Mr. Mitchell's red sedan is registered to him, and what the discovery shows is that 6 minutes before the 911 call was made, Mr. Mitchell's red sedan was seen on an LPR camera, a 12-minute drive away from the incident location. Furthermore, Judge, we have had the opportunity to speak with Mr. Philpott under oath. Mr. Philpott told us—
How was that?
It was very interesting, Judge.
How was he? I'm curious, what was the setting that you got him under oath? What kind of hearing?
Your Honor, pretrial hearing on a motion to suppress his identification of Mr. Mitchell.
Oh, and he testified at it?
Yes.
Okay.
And at that hearing, Judge, he told us that at the time of the identification, he had been in the hospital for several weeks, I believe, at least some time since the shooting, that he was on pain medication, that he had been on pain medication for a while, that it was affecting his cognition, and that it could have affected the reliability of his identification. He also made it very clear it was 88 Patton at the time, to 88 Patton and me and to the court, that he did not want to participate in the prosecution of this case, that he had forgiven whoever had shot him, and that he was not interested in cooperating. And so I believe that all those things factor into the state's decision to make this offer. And of course, Mr. Mitchell wishes to accept this offer because trial is a huge risk. Trial carries the risk of going to prison and being away from his family and not being able to care for his children, for many years. And Judge, he's never faced that kind of risk before. He did successfully complete a first offender sentence. It was on probation. But Judge, Mr. Mitchell and I have discussed the risk of trial. We do have an out-of-court identification of him that was permitted into evidence at trial.
So the ruling was not that it's suppressed, just the jury would decide the weight of that identification based on Mr. Philpott's acknowledgement that pain meds were interfering with them, et cetera.
Yes, Your Honor. Ultimately, Judge Ingram ruled that there was no misbehavior on the part of the police in administering the identification, and that the identification, therefore, was legal.
Okay.
That's all I have, Judge. Thank you.
All right. Did you want to add something?
I would just say that, the state has had discussions with the victim as well in terms of cooperation. And, I was not present for the motion to suppress, so I don't know quite about the issue of the pain meds, but in terms of our evidence time, Mr. Mitchell is the victim's testimony, and as of this time, he is quite uncooperative.
Okay. Does he know how this case may end? Has he been informed of what the offer is?
He expressed, I think that he has had some prison sentence as well, and he was hesitant to send Mr. Mitchell to prison.
Mr. Mitchell, what was your other case? You were a first offender probationer on something. What was that?
They were death by receiving stolen property. I had bought a stolen property and I didn't know it was stolen, and
What was it?
it was a car.
Okay. How long ago was that?
It was in 2019. I had got 10 due 2, served 2 years, and I did 8 years straight on probation.
Where was this?
Fulton County.
You got 10 due 2 for a stolen car?
Yeah, Judge Russ.
Was it her car?
Nah, it was somebody else's car. I don't know, but
Okay.
she gave me a 10 due 2.
That's quite a sentence. Okay. Do you have kids?
I got 9 kids, Your Honor.
9 kids.
Yes, sir.
Okay. How young is the youngest?
6 months. They were
Oh.
twins.
Twins. How old is the oldest?
17.
Okay. That's a lot of kids. How do you support all those kids?
I got 3 jobs, Your Honor. I wash cars. I mow lawn. I even help my granddaddy sometime when we gotta go do painting. I work all around.
Okay. Are you planning on having more kids?
No, sir.
Why would you stop now?
It's a lot.
Well, I think 7 was a lot, and you just added 2 more.
I can't help what God bless me. He blessed me with 2 sets of twins, Your Honor.
Okay. Hopefully he blesses you with some discretion coming up soon too, and you stop having kids. But it's up to you. It's just they're going to rely on you, and that's a lot of work. Good luck with that. Do you have any questions about anything we've been talking about?
I don't think I got a question about y'all. I'm just taking this plea. I didn't hurt no one. I didn't do that. But I'm just taking this plea because I don't want to go to trial. And I know
And
this.
you've told me that. My question was, do you have a question? Not, do you want to make a statement?
Okay, my question is, if I take this plea, will it take my rights as, I understand I'm gonna be a convicted felon, but if I do so many years of being good on probation, will they take that convicted felon off so I can get a job and work?
So good question. Few things. One, you're still going to be able to get jobs. I work with plenty of folks in our accountability courts who have 5 felonies or 7 felonies and they get jobs. It's harder. You're not going to walk into a bank and say, I want to be a bank teller. And they're going to say, nope, you can't do that. But there are plenty of jobs that you'll be able to get. But number 2, if you successfully complete your sentence, you can work to have it what we call expunged or somehow, I don't know all the terminology, but have your record restricted. But that is a little ways down the road. That would be, it happens automatically with the first offender, but you've used that one up with the real fancy stolen car. But with this case, you'll need to wait until your sentence is complete, and then you could inquire. There are a number of organizations that help people do just that so that it doesn't get in your way as you are just trying to get back to other types of jobs. You're still going to be able to work. You're not prohibited from working while you're on probation. And as I said, there's still plenty of jobs you can get, but there'll be some that the employers will say, no, thanks, because they'll see that you're a convicted felon. So it'll make it harder. Did that answer your question?
Yes, sir.
Okay. Any other questions?
No, sir.
All right. Well, Mr. Mitchell, I find there's a factual basis for your plea. I understand you're saying it wasn't you and you weren't there, and there may even be evidence that your car, if not you, was 12 minutes away from a place 6 minutes before the shooting happened, which would make it hard for your car to be there at least. But based on Mr. Philpott's identification and his testimony, a jury could find you guilty. And I suspect that's why you're taking the Alford plea. As Ms. Lake pointed out, it's a pretty big risk to go to trial if that doesn't end well. And then we're not talking about the kind of sentences we're talking about here. So I'll accept your plea as an Alford plea. I also find that your plea is knowing and voluntary. That means that you've understood what we're talking about and no one has forced you to enter the plea. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that while you're on probation, if you have a minor violation with probation, maybe you miss a meeting or something like that, you don't have to come back to the judge. You and probation will work through that. But if it's more serious, you get arrested for something like that, then you'll be back in front of the judge. And that'll be Judge Ingram, not me. Mr. Reed, no restitution for any kind of medical bills for Mr. Philpott?
Not that we've been made aware of, nor is it anything he's asking for.
Okay. Ms. Lake, is it okay if someone on either Judge Ingram's staff or mine signs the indictment on your behalf?
Yes, Your Honor.
Can we sign for you, Mr. Reed?
Yes, Your Honor.
Mr. Mitchell, is it okay if we sign your name on the indictment indicating your Alford plea?
Yes, sir.
We'll do that. Do you have a weapons carry license?
No, sir.
You understand that when you leave here today, you will now be a convicted felon, so you can't have guns. If there's a gun in your household, even if it's not yours, it needs to get out of that household. They can't be in your car or cars. They can't be in your house or houses. You need to not be around them. It's a separate offense. You were charged with it here, but it was the wrong charge. It didn't apply to you. But going forward, it will be a felony offense for you to have a gun. Do you understand that?
Yes, sir.
Okay. Mr. Mitchell, I will follow the negotiated resolution based on all the information I was able to learn about the strengths and weaknesses of the state's case. Count one, I'm going to follow it generally. I'm going to structure it a little bit differently, but hear me out. Count one is going to be 5 years to serve 90 days with the balance probated. Count two is the same, and count three is 5 years probated consecutive to count one. So the total sentence is 10 years to serve 90 days with a balance on probation. I just moved that 5 years suspended down into the 5 years probation after the 5 years probation for the ag assault and the ag battery. So 10 years to serve 90 days, balance probated. Special condition of probation number one is that you stay away from Mr. Philpott. You may not know the guy, but if you know who I'm talking about, if you ever see him, you need to walk away. Let him go his direction and you go your direction, okay?
Yes, sir.
And is there any reason you need to be at that gas station where the shooting happened?
No, sir. I wasn't there, sir. I really wanted to take it to trial, but
I hear you. I'm not pressing you on it, but that's not a gas station where you normally spend lots of time?
no, sir. I grew up in that neighborhood. I don't spend no time at that gas station.
Okay. Well, I'll have you stay away from the incident location as well. So stay away from Mr. Philpott, stay away from that gas station, stay focused on your 9 kids and counting, and your 3 jobs. And we will take it from there. Mr. Reed, anything else for the state?
No, Your Honor, thank you.
Ms. Lake?
No, Your Honor, thanks.
All right. Is your residence in Fulton County?
Yes, sir. I'm facing a conviction right now, so that's why I couldn't afford an attorney. So but I'm staying in the Fulton County.
Okay, well, you had a great attorney for this, so you shouldn't worry about that. I asked about your address only because Ms. Simpson's going to give you reporting instructions for probation, and it just depends on what county you live in. Are you going to stay in Fulton County?
Yes, sir. I'm staying I got an address for Fulton County. Yes, sir.
Okay. Well, why don't you talk with Ms. Simpson when you're done talking with her? If Ms. Lake says you can go, you're free to go. Okay?
Sir.
All right.
All right.
Thank you, Judge.
You're welcome.
Thank you, Judge.
Good luck. Mr. Abikwe, did your
Yes, Your Honor.
client say up?
She's come on here. Please here. Put your head here and say good morning to the court, sir. Good morning, sir. Put your head.
There he is. I would recognize those coveralls anywhere. So let's just talk real briefly about what's going on. It sounds like, Mr. Abikwe, you and Ms. Dilligard were not able to reach a negotiated resolution. Is that correct?
Judge, yes, and we're still talking. We spoke briefly this morning, and hopefully we'll be able to resolve the case without the need for unnecessary litigation. However, if everything fails, Judge, I will ask that we put on the next trial calendar.
That's what we'll do. I listed a few other cases as being ready for Monday, so I will not add this to it. And I guess we can add this as a supplemental case to an upcoming trial calendar. Ms. Dilligard, does it seem like you all are far away, close, or how would you characterize it?
Judge, counsel is asking for a null pros, and I'm not quite there. I'm gonna go back and review the evidence a little deeper, but my understanding of the facts differs from counsel a bit. So I don't know how to categorize that, but we will continue negotiating, and I will look into the evidence a little bit deeper to see if I can identify what council is speaking of.
Okay, well, that's a little bit of a hurdle you'd have to clear. I will put this on the next available trial calendar. Mr. Benjamin, we will see you on that date. You'll get notice of it. Your lawyer will get notice of it, and we'll figure out what we're going to do then. Do you have any questions? Okay. Mr. Abikwe, I'm sorry for your family's loss. Are you going to be stateside for a while, or are you going where?
This happens in Los Angeles, but the body has to be taken back home. So I don't know yet, Judge.
Okay. All right. Well, our next calendar is not for a bunch of weeks, so I'm assuming you'd be back by then.
Yes, Your Honor.
Okay. All right.
Thank you, Judge.
You're
Thank
welcome.
you, counsel. Thank you, Ms. Dilgay.
All right.
My business concluded. May I be excused?
Yes.
All right, thank you.
Thanks. All right. I do, yeah. It's listed as one of, Deidre puts it under the conditions of probation. Judge Ingram doesn't do that? Wow, okay. That's what we always do. So that case didn't work out. Is Mr. Gomez up? Yeah. Great. Have you had you got to go talk to him? Great. Should we do Ms. Scott?
Yes.
Yes. All right, Ms. Scott, if you would please come up to the podium.
Judge, can you bring us Judge Matthews right there? No, Judge, it's not.
Good morning. Are you ready to go?
Oh, yes, sir.
Great.
I'm
Okay.
sorry.
Then let's get on the record in State versus Lauren Scott. This is 24 SC 004909. Ms. Scott is here in court with her lawyer, Ms. Rios. Ms. Clark is the prosecutor. Ms. Scott, in a moment, Ms. Clark is going to put you under oath. Ms. Scott, you there? Okay. She's going to put you under oath, and then you'll be asked a bunch of questions about your rights. Do we need to sit? Would it be better if you all were at the table?
Yeah, you want to sit down? Yes, let's sit down.
Okay.
Come on, take a seat.
Oh, sure you want to call.
Radio. So many service vision. That's a George Ocean, Robert. Joseph Ocean, Nancy, C. as in Charles. Oh, shit. Hold me out at 185 Central on the 8th floor. Could you start filming my location? That's email. Also have the chemical tap. The 8th floor, 8D as it goes.
Miss Scott, take your time, okay? Just stay seated.
Give it some time.
Would you like some water? Thanks, we were getting water.
Oh.
Great job. I'll tell you what, we'll give you the water that we bring out, so you leave with one. You took too long, so we got water ourselves. Ms. Scott, I'm happy to handle a different matter if you want a little bit of time. You want to try going forward? Yes? Okay. Well, let's do that. You stay right there. We will have Ms. Rios sit next to you, and we'll just get the microphone there, and we'll see what we can do. And you let me know if you need to take a break, okay? Should we cancel the ambulance? Okay. All right, we're going to take this slow and easy, and if you need a break at any time, will you let me know? Yes? Okay. The one thing I am going to need you to do, though, is that when you're answering questions, I'll need you to answer verbally. You're welcome to nod your head, but yes or no, or whatever your answer is, okay? Thank you. All right. Well, we're going to get back on the record in your case. And the way this is going to work, Ms. Scott, is that Ms. Clark's going to ask you some questions, and you need to answer those to the best of your ability. If you don't understand the question, let me know or let Ms. Rios know, and we'll do our best to explain it, okay? They're not meant to be complicated or trick questions. They're just covering your rights. And then I may have a few questions. And ultimately, I will hear from Ms. Rios and from you as well, okay? All right. Ms. Clark, why don't we try to get started?
Yes, Your Honor. Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury? I didn't hear you.
Yes.
You can put your hand down. Please state and spell your correct legal name.
Weinstein,
Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Is there a medication that you normally take that you have not taken or been given today?
Yes.
There is medicine that you normally take? Pardon me? Okay, you take diabetes medicine? Did you take that medicine today? Can you move the microphone towards her, please, Ms. Rios? When you don't take the diabetes medicine, does that make it hard for you to understand what's going on? Like right now? Okay. But it doesn't interfere with your ability to understand what's happening. You just feel miserable. Okay.
How old are you?
37.
What's the highest level of education or the last grade you completed? Where did you go to high school? Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, cruelty to children in the first degree. Count 2, aggravated battery. And count 3, cruelty to children in the third degree. Do you understand that you have the right to plead either guilty or not guilty to these charges? Do you understand that if you plead not guilty,
I'm
then
not
the
here.
state is required to prove the charges against you at a jury trial? I didn't hear you.
Yes.
Have you had an opportunity to review the indictment with your attorney? And did you understand the indictment as explained to you by your attorney? And have you had the opportunity to review your waiver of rights with your attorney?
Hello?
Yes?
I'm not hearing any responses.
Okay, we'll make sure that Ms. Scott,
The last question I have is, have you had an opportunity to review the indictment with your attorney?
Yes.
And did you understand the indictment as explained to you by your attorney?
Yes.
Have you had an opportunity to review your waiver of rights with your attorney?
Yes.
And did you understand the waiver of rights is explained to you by your attorney?
Yes.
Is it your decision to waive your rights today?
Yes.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges? Are you satisfied with your attorney's services?
Yes.
Attorney Rios, do you waive a formal reading of the indictment?
Yes.
Do you waive any defects in the indictment for purposes of this plea?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
For count 1, it's 5 to 20 years in prison. For count 2, it's 1 to 20. And for count 3, it is a misdemeanor charge, so it's 1 day in jail up to 12 months in jail. Do you understand that your plea today is called a non-negotiated plea? And the state may recommend a sentence to the court even without your having agreed to it? I didn't hear you.
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the court enters its sentence?
We kept the final plea rates.
Oh, okay. Do you understand, since you've kept your final plea rights, you do have the right to withdraw your plea and demand a jury trial. Right?
Yes.
Your Honor?
I'm assuming I don't have the trial calendar in front of me, so I trust Ms. Rios. If she says the final plea rights were preserved, then if the sentence I give is different from what Ms. Rios asks for on behalf of Ms. Scott, she'll have the opportunity to withdraw her plea.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
This is also an outward plea.
Yes, ma'am. I haven't gotten to that part, but,
Not outward plea, sorry, first offender plea too. Oh,
Okay.
outward and
oh, yes, ma'am. Okay. Do you understand that this is a guilty plea, which is permanently recorded on your criminal history? I didn't hear you.
Yes.
Are you currently on probation or parole?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today? Do you understand that if you're on probation, you must follow all the special conditions of your probation? Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation? Are you a United States citizen? Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or no contest to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
I don't think so. No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
Yes.
You understand that this means that you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in the indictment against you?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Defendant Scott, is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today? Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you're in fact guilty?
Guilty under oath.
Are you pleading guilty because you have decided that it is in your best interest to do so? Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment number 24 SC 004909, how do you plead to count 1, cruelty to children in the first degree?
Guilty under oath.
How do you plead to count 2, aggravated battery?
Guilty under oath.
How do you plead to count 3, cruelty to children in the third degree?
Guilty under oath.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Do you understand that you only have a limited right to appeal this guilty plea conviction? Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date? I didn't hear you.
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition? Your Honor, at this time, the state will provide a factual basis for the plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on December 12th of 2022, at approximately 11:50 hours, officers from East Point Police Department were dispatched to the incident location of 2408 Stone Road, Apartment 13, East Point, Georgia, in Fulton County, in reference to a suspicious person call. Upon arrival, officers observed a Black female identified as Rachel Nim. Nim is spelled N-E-M-B, covered in blood, standing on the landing of the second floor, screaming and crying. There was another female, Lauren Scott, standing in the doorway of Unit 13 with a blood stain to the upper right side of her T-shirt. Miss Nim was crying and screaming, "My baby, where's the ambulance?" There was another female standing in the doorway of the adjacent unit holding an infant. The infant was Jaziel, spelled Jaaziel, Nims, 6-month-old child, covered in blood with a towel against his forehead. Officers Bailey was unable to take photos of the injury to the minor child's injury due to the need to keep constant pressure applied to the injury. He asked the female holding the baby, Bianca Dalton, Bianca spelled B-E-Y-O-N-K-A, what happened. Ms. Dalton stated she was inside of her residence when she heard Rachel Nim, screaming on the front porch. Dalton stated Nim ran back into the house and brought the infant outside covered in blood. Ms. Dalton stated she then saw Scott come outside yelling, "I wasn't trying to kill your son." Officer Bailey asked Ms. Dalton if she heard or saw anything prior to Rachel Nim coming outside, and she stated no. Officers then returned to Ms. Nim and asked her what happened. However, she was extremely hysterical and would not answer questions. Officer Bailey entered Unit 13 and spoke with the defendant, Scott. Officer Bailey observed a metal serrated spatula with a black handle lying in the living room floor in front of the Christmas tree. Defendant Scott stated that her oldest daughter asked for the spatula, so she tossed it toward her daughter, but her daughter moved, which caused the spatula to hit the infant in the head. Officer Bailey proceeded to a back bedroom where he observed 3 other juvenile females, a 5-year-old, a 4-year-old, and an 8-year-old sitting on an air mattress. Defendant Scott began speaking to the 8-year-old minor child with the initials ZR, stating, "I wasn't mad at you. I wasn't trying to hit you." ZR then stated, while crying and trembling, "ZR, I was so scared, Mommy. You scared me so bad." Scott responded by stating, "I wasn't fussing at you. I was on the phone and I just want to be left alone. I haven't had any sleep." Officer Bailey was then advised per Sergeant Broussard that the juvenile stated that the mother Scott was upset at them because they weren't cleaning their room. Defendant Scott then picked up the spatula and threw it overhand in the direction of minor child ZR. However, ZR ducked to dodge the spatula and it hit the minor child JN in the head. While awaiting Grady EMS arrival, Defendant Scott began stating, "I was fussing at somebody on the phone, but I wasn't mad at my kids. My ex-boyfriend, I'm running from him, stalking me, and we were arguing. I don't even know why, something, this indecipherable." Okay, officers then took pictures of Scott's shirt and neck area, then allowed her to change in a clean shirt. Scott was then placed in double locked handcuffs to the rear and checked for proper fit. Detective Philpott transported the 3 juveniles to Fulton County. Your Honor, the state have a few pictures that I want to be shown in this case. Bear with me and give me a moment.
Can I object? I'd like to object to showing pictures. We're not at trial. Like, this is a plea.
Okay, but in terms of establishing the factual basis, tell me what's your objection other than that you don't like it?
It's irrelevant. It's on music.
Okay, you can, as long as you're not, this looks like almost like an opening statement or something.
Yeah.
If you're not going to go through all the slides.
No, I'm not, Your Honor.
Okay.
Okay, all right. I just happen to have done it. Okay, so I'm gonna pass through the slides. First of all, Your Honor, I want to say that the victim in this case, victim's mother, is, still distraught and suffers from PTSD with this situation. The mother of the child has been intimidated by family members of the defendant, and threatened by her. So much, in fact, that she is not cooperative, even though she has explicitly said to us that she wants the defendant in this case to have jail time. Jail time in this case. We're asking, Your Honor, for our offer. We're asking for 20 years to serve 10. The reason why is because based off of the circumstances and the facts in this case, this was not an accident, Your Honor. The defendant was trying to throw this spatula that's here on the screen to at the 8-year-old child ZR. Okay. It looks, if you see it up close, it's an actual, I've seen it in person. It's an actual outside spatula that you use for a grill. This is the child on the crime scene. This is a 6-month-old child. The child at this point, because of the injury suffered because of the defendant Scott's actions, the child has suffered a right eye puncture where the optic nerves and everything in the cornea has left this child blind, and the eye is removed. This child would not be able to see out of this eye for the rest of her life. Your Honor, the defendant, the criminal history in this case, the defendant you will see has misdemeanors. She doesn't have any felony convictions, that's true, but she has had a number of misdemeanors where even as early as 2005, a simple battery. She was allowed to do a pretrial diversion program in 2013. Matter of fact, she did not show up to the calendar call on May 8th because she was in jail for a charge in Clayton County. This defendant has a violent streak. We anticipate defense may say that she is a victim of domestic violence. However, Your Honor, this innocent child at 6 months old lost an eye because of the fact that this woman was trying to throw the spatula to hit her 8-year-old child because she was upset with her child. The victim did provide to the doctors in the hospital, and this is the only slide I want to show. In the medical records, she indicated, the victim said, because she was actually staying in the defendant's home. She said, she told the DHS person there that she didn't want to provide a statement, that she was traumatized, and that Lauren Scott, the defendant, was her roommate. She threw a metal spatula at the 8-year-old, and her child, Giselle, was sitting on the floor nearby and struck in the face. Rachel Nim, who is the victim child's mother, said that she has witnessed defendant Scott physically abusing her children and recalled an incident when the mom was doing Zenyaya's hair, and Lauren was beating Zenyaya on her back with the same spatula that injured the child in this case. Nothing further from the state, Your Honor.
All right. Ms. Simpson, do you have any criminal history information for Ms. Scott? Okay. Ms. Rios, I'm going to let you share anything and everything you want to share, but please start with, what was the Clayton County situation? Ms. Scott wasn't able to make it to court recently because she was locked up for something.
So that was a 2023 warrant for a simple battery against her ex's mother, her ex is the one she's had ongoing domestic violence situation with him being the defendant in those cases. I actually said Ms. Clark reports, and there were cases of him abusing her. There was an incident where he came to her house with his mom. They were trying to fight her. She was in a fight with the mother-in-law after she attacked her. But she only pled to that case in hopes of A, trying to get to her kids, because her cousin said, I can't keep your kids anymore, and B, to try to make this court date. And so she was actually released that evening after court. As soon as she was released, she called me and explained what happened. And so she's on a misdemeanor for that.
Okay, got it. Thank you for clearing that up. What do you want to add?
First, I want to start with the injury to the child. I received no medical records showing that child lost an eye. And in fact, my client says she has seen the child, but he is not missing an eye. And I would think that if that was true, I would have been provided with medical records saying that child has not had an eye. She just said that the victim's mother has not even been cooperating with him. So I don't even know any updated information of how the child is doing. She has not provided any of that. My understanding is the child is able to see and has not lost an eye. There's no indication that an eye was removed. This situation, she was in a very bad mindset because she was in this domestic violence situation trying to run. She was in Texas trying to, you remember before, she was living in Texas trying to get away from that situation. She since have come back because she understood that she would probably at least have probation here, and she actually secured a job here, which was what I sent the court. In this situation, she was not trying to, I think first degree does not fit. I think maybe second degree. She was not trying to hit the child or her daughter, an 8-year-old. She was tossing it. She's on the phone as 8-year-olds do, asking stuff. She tossed it. The girl was asking for the spatula. Yes, she was reckless in the route of how she's threw it, and probably should have made sure it was not going to hit anyone, or the child away. But she was not intentionally trying to harm her daughter, nor was she ever intentionally trying to harm a 16-year-old baby. She even realized there was a baby on the floor. The mother of the child, she took it because she was homeless. So she had her come stay with her and the baby to make sure that that's why they were living with her. She was not trying to harm that family. She was actually trying to do something good by helping them because they were going to be on the street. She wanted to take them in to harm the child. Now, in regards to the past incidents of DFACS did an investigation and let her keep her kids. So all 3 kids are in her custody. She has a 10, 8, and 6-year-old who are all residing with her. And I believe that's part of why she had this panic attack, because she has nowhere for her children to go. And she's worried that they're going to end up in foster care. Her goal has been to protect her kids. That's why she's been trying to keep them away from her ex, doing what she can, but things just haven't been working out in her favor.
Is her ex the father of the 3 kids?
No. And so we were asking for, in this case, on count 1, 10 years probation, on count 2, 10 years probation, and count 3, 12 months probation, with a behavioral incentive date of 5 years and under first offender. Any other conditions that Your Honor would think are appropriate, she'd be willing to do. She just doesn't want her 3 kids to go into the system, and she wants to be able to continue to provide for it. This was a tragic accident. She feels very bad that the child was hurt. This was not intentional. This was not, if the defects thought that she was a harm to her kids, they would have taken them away. And so I'm just asked that you let her do probation so she can continue to be a mother.
Ms. Clark, what's your understanding of the DFACS situation? It looked like there was a little blurb that was DFACS related, but if Ms. Scott's 3 kids are still with her, then DFACS must not have had ultimately a serious or substantiated concern about their welfare if they stayed with mom.
I think that they did an investigation, but before this happened, it's my understanding, I don't know if it's because related to whatever the prior cases or whatever with the male she was involved with, but it was like a thing where they had, DHS had told, I guess, the defendant that there was to be no physical contact, whatever, prior to this incident. Now, I think that was related in full candor. I think that was related to because of the domestic violence situation, but it was a circumstance of something similar to that. I think the DHS did an investigation because of the fact that the child, they made a determination that because the child was not her biological child, but was in fact Miss Nim's son, they made their assessment based off of that. I know there was an investigation done, but that's all I know. I know that we're asking for 20 served 10. And then after if she's on probation, then she'll need to complete a family violence course. And I know we are also, the state is opposed to the defendant being granted first offender. We know that that is discretionary. We feel that based on the circumstances in this case, that the defendant should not be given first offender.
Have you or has an investigator in your office had an opportunity to speak to Ms. Scott's eldest daughter?
No, we have not.
So we have Ms. Scott's version of events that she was tossing the spatula to her daughter because her daughter, for some reason, wanted the spatula. And then the daughter saying, "You threw it at me."
Right. The daughter was saying it, and on the body worn camera footage, Your Honor, the officers they're interviewing the children. We believe it's the state's position that the defendant said that initially, saying it was an accident or she didn't mean it. She wasn't trying to throw it because she was trying to evade being arrested or being held responsible. Because if you see the conversation that she had with the child after the fact was, she was saying, the child was like, oh, I'm so scared. And she's like, I wasn't trying to hit you. She was saying, I was fussing at somebody on the phone. The Rachel Nim, the mother, indicated that she was upset with whoever she was arguing with on the phone. Her daughter was asking her something or whatever. She was agitated with her daughter. In order to get her daughter to shut up, she threw the spatula at the child. And the spatula instead, because the child ducked down, didn't hit the child, it hit that baby. That's what happened in this case, Your Honor.
Okay. Ms. Scott, do you have family in the Atlanta area, or is your family in Texas? I don't mean your kids, obviously they're with you, but do you have siblings or parents in the Atlanta area? Where is your family?
I don't know.
You don't know?
I was a foster kid.
Okay. So when you went to Texas, did you take your kids with you?
Yes.
And they're here, they're back here now?
Yes.
Where, do they have the same father or different fathers?
My oldest daughter has a different father from my younger two children.
Okay, and is either father active in their lives?
No.
Are the fathers in the Atlanta area?
Honestly, don't. My kids were born here, so I would assume yes.
But you haven't, they have not been active in the kids' lives?
No, sir.
Judge McBurney, family members, she does have family here in Atlanta because they've been threatening the victim and intimidating the victim child's mom.
So you say that, but tell me why you say that. I'm not disagreeing with either side. I don't know, but we don't have consistent versions of events.
When, I guess before, at the beginning of this, the victim child's mom, she was all for, wanting to come to court to.
No, I understand that, but
she indicated to us, we tried to get her to give us, to calm down.
her story to you or your investigator was that Ms. Scott's family members are getting at her.
Yes.
Okay.
Judge, can I say something?
You sure can.
I don't have family. I was emancipated at 16 years old, so I had gotten in trouble in the beginning parts of my life. I was just trying to get by. I was very, but I don't have family. I don't.
Your family is you and your 3 kids.
Correct.
Are they in school?
Yes.
Where do they go to school?
Snapfinger Elementary.
And are you working now?
Yes.
Doing what?
I'm a property manager.
The letter that Ms. Rio shared with me, is that a new opportunity, or that's what you're doing, that particular one?
This was something that I got to come back here. I was living in Texas when this case started, so well after I had moved to get away, and then I came back once I knew that, everything was, legally, I had to be to court, and I just didn't have the means to keep going back and forth, so I just came back.
Are you all living in an apartment complex, or I don't need your address, but generally, where are you staying? Ms. Clark, what's your understanding of what would happen to the three kids if Ms. Scott went into custody?
My understanding would be that they would go to a next of kin. Um,
And if there's not next of kin?
then they would be placed in a foster home until until foster care in placement. I just, being that somebody was living with her, this Rachel Nim was living with the defendant before, and she observed this woman hitting the child, disciplining the child.
Right, but if that had been substantiated, why would the kids still be with mom?
Well, Your Honor, DHS, they are overworked, underpaid, and sometimes if they feel like the immediate children of that particular person, those kids, there are no bruises or anything on that child. In the DHS paperwork from my review, they were concerned about the fact that, okay, this child is not the biological child of the defendant, and Miss Nim and her son would be living somewhere else and not with the defendant. That's what their investigation was. They're gonna look and see if there are bruises and marks on the children there, because the injury was with that child. I'm just saying, looking at the totality of the circumstances, the fact that she has had several misdemeanors, were simple battery, over and over again prior to, and regardless of her explanation, it's blaming someone else. It's because of the relationship. Like literally, her daughter told, and you can see it on the body worn camera footage, she told her mom was she was scared and terrified because her mom was really upset. And that woman, regardless of whether or not she didn't intend to hit the baby, she was trying maliciously to hit her own daughter. And just so happened the daughter is 8, so she had the capability to duck down. But this baby that's 6 months old could not do that. They couldn't fend for himself. And as a result, whether his eye or whatever, he doesn't have the use of his eye. So I don't know what medical records defense counsel has reviewed, but it clearly says that Dr. Messner's report, the child will never be able to see out of that eye.
I think maybe some of the confusion was, did the eye actually have to be removed? To me, it doesn't matter whether it's still there or not. If the kid was blinded in an eye, that's a pretty severe injury. It doesn't sound like that was the intent of Ms. Scott, but it certainly was the natural cause that could be expected to occur when you throw a spatula like that in the direction of kids. So I follow you on that.
In the reports, it said the child could lose visible. And I would think that the mother would provide reports saying, because this happened a while ago.
This is all very old. That's also making this complicated.
What the status of the child's eye would be today. And since we don't have that, which I would think would be like, she would give that to us if the child is blind in one eye, I would think we would have reports saying currently the child is blind in one eye. And that doesn't seem to be the case. It seems like the mother doesn't want to communicate with Ms. Clark. And so we don't have updated information about the status of the child. And additionally, I think it's ridiculous to say that, oh, GFAX was only looking at the other child. But there were allegations that her daughter was scared and that the children get beat other times. GFAX is looking into that case. And they determined that Ms. Scott could keep her kids.
Can I say something else, please?
Your Honor,
No, let me hear from Ms. Scott. Yes, ma'am.
Your Honor, I didn't even know Miss Nim. I didn't know her. She was dating a friend that was married. He dropped her off at my doorstep. I bought her clothes, fed her, housed her, took care of her child. This was a very much freak accident. I'll admit, yes, I should not have thrown that spatula, but my child and her child were on two opposite ends of the room. My daughter was facing the left side. Her son was sitting by the door on the right. I didn't even know he was there.
Didn't know he was in the apartment, or?
I didn't know he was sitting on the side of the couch on the floor. I didn't see him at all.
Okay.
Your Honor, so I want to be clear. The victim, and my advocate is on Zoom observing, and she can be a witness to this. The victim is in communication with us. She explained to us that she's afraid to come to court. She also indicated, we asked about the child, the status of the child's eye, and she said that her son will not ever be able to see out of the eye. Now, if the case would have went to trial, or if it goes to trial, Your Honor, we are going to have medical records that are showing the progression of the child's injury from 2022 up to present. But defendant said that she wanted to enter a non-negotiated plea.
Okay. Got it. Ms. Scott, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. That means you've understood what we talked about and that no one's forced you to enter this plea. Do you agree with that? All right. I'm going to sentence you pursuant to the Probation Options Management Act, which means while you are on probation, if you have a minor probation violation, you and probation will sort that out. But if it's more significant, you get arrested for anything, or there are any defects, issues with your kids, that would come back to me. And we'd work through what the consequences will be. Ms. Rios, can someone in my office sign the indictment on your behalf? Ms. Clark?
Yes, sir.
All right. And Ms. Scott, can someone sign for you? Okay. Ms. Scott, this is a complicated case, and I, of course, am operating on limited information. I have your version of events through Ms. Rios. I have the state's version. My guess is what happened is somewhere in between. What is without a doubt is that Jazeel was pretty seriously injured. That was a big old gash. It sounds like that eye doesn't work anymore, but in some ways it doesn't matter. It was serious. It was reckless on your part. I don't think you were tossing it because your daughter really wanted the spatula. I think you were tossing it because you were trying to get your daughter to either leave you alone or be quiet. And that's the recklessness that makes this more problematic for you, as opposed to your daughter really wanted it. Instead of walking over to you to get it, you tossed it to her. I don't think you were trying to blind the infant. That there's nothing in this case that suggests that was your intent. But sometimes doing things when you're angry that are meant to get someone to be quiet or leave you alone have worse consequences than you intended. And there's still consequences that you have to be responsible for. So let me describe for you what I think is a reasonable sentence without making the NEMS family go through trial and bringing your daughter into court and having to testify, et cetera. Then I want you and Ms. Rios to talk about it, and we'll figure out whether you want to go forward with this or if you want to have a trial. On count one, I'm sentencing you to 10 years to serve 6 months with the balance on probation. Count two is the same, and count three is 6 months in custody. You won't go into custody today. We would agree on a turn-in date when, and not too far out in the future, after you've gotten things settled for people who'll be on the outside, and then you'd be in custody for those 6 months. Then you'd be on probation. I will sentence you as a first offender at this juncture, if that's what you want to do. And the special condition of your probation would be 1, no contact with the NEMS family, and 2, you complete a family violence intervention program, which is a series of classes that just help you juggle better all the stresses of being a single mom with kids who pull you in lots of directions and stress you out. so that you would avoid a situation like this again. I can't see this as a straight probation case, given how seriously the little guy was injured, but I don't believe that it was at any point your intent to injure is it a boy or a girl?
A boy.
Okay, that it was your intent to injure the little boy. I don't know that you were reminded if it whacked your kid on the head since you were tossing in her direction, but it didn't hit her. And I don't have to go there. So I'm going to ask the two of you to talk about this a little bit and get back to me in a few minutes about what you want to do with this, okay? Oh, you can, I'm going to give you more time than that. We're going to pivot to another case and you guys can talk through it. Ms. Wood, could we do Jin Tao? Are you ready now?
But with the court's permission, I think Ms. Lake and Ms. Washington are ready to go ahead of me. I'm not ready yet.
Oh, okay. Poor Mr. Jin Tao still on the call? Okay. All right. Then let's do Mitchell number 2.
You see me on the. Yeah, check me.
Okay, I'll do it right now. All right.
Is this a simpler plea? We have had a shooting and an eyeball. I'm not taking any more complicated pleas.
Although I don't see Mr. Mitchell on Zoom anymore. Oh,
Yeah, I'm here.
okay.
Sorry.
All right, you should turn your video on, Mr. Mitchell.
Okay, one moment, please.
All right, and when we're done with that, maybe we can do Javon Redmond, who have had Ms. Adams on for a long time.
Yes, thank you, Your Honor. We'll be ready.
Excellent. There we go. All right. Everyone ready?
Yes, Your Honor.
Okay, let's get on the record in 22 SC 180754, State versus Keith Mitchell. Mr. Mitchell is appearing virtually. Ms. Lake is here in court representing Mr. Mitchell, and Ms. Washington is here in court representing the state. Mr. Mitchell, I'm Judge McBurney. We have not met before. I don't think. I am filling in for Judge Ingram, who has a trial going on right now and asked me to cover the plea. You have a right to be here in open court with your lawyer. Are you waiving that right so that you can appear from wherever you are?
Yes, sir, I am.
Great. I need you to be on the camera and not the ceiling. There you
I
are.
can barely hear you. There's construction work going on behind me.
Well, that's on you. You need to find a quiet place or come to court, okay?
All righty.
All right. You also have a right to have Ms. Lake by your side, but she is in here where there is no construction work going on. Are you waiving your right to have your lawyer by your side?
At this moment, yes, I am.
Okay. Well, you don't get to change your mind partway through. Are you going to get through this plea with Ms. Lake here and not with you?
I trust Ms. Lake. Yeah, we can proceed.
Okay, we're going to proceed. Ms. Washington, when you're ready.
Thank you, Your Honor. Mr. Mitchell, can you please raise your right hand? Do you
Yes.
solemnly swear or affirm that the testimony that you will provide to the court is the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand. Can you please state your name, age, and date of birth?
My name is Keith Cortez Mitchell Jr. Age is 32. Birthday is September 3rd, 1992.
Are you now under the influence of any medicine, drugs, or alcohol?
No, I'm not.
How far did you go in school?
Some college.
Can you read, write, and understand the English language?
Yes, ma'am.
Have you had an opportunity to review the document that charges you in the case today?
Yes.
And do you fully understand the nature of the charge pending against you?
Yes, I do.
Do you understand that by pleading guilty today that you're giving up the following rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself.
Yes, I do.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on this charge by jury?
Yes, I understand.
And do you understand that you are pleading guilty today to aggravated assault strangulation, which is being reduced by the state to simple battery family violence with a range of punishment of up to 12 months?
Yes, ma'am.
Are you now serving any other sentence? Are you now on probation or parole for anything anywhere?
I am on probation.
Do you understand that by pleading guilty today, that if you are on probation, that your probation will almost certainly be revoked?
Yes, I understand that.
And this is a negotiated plea, and the state has made the following recommendation. For count 1, aggravated assault, the state is reducing to simple battery family violence with the following recommendation: 12 months probation, and for you to complete the family violence intervention program and have no contact with the victim Quindarius, Quindarious Smith, until you complete the family violence intervention program.
Correct.
And Judge, if I may just place something on the record, Mr. Mitchell is on probation currently. However, his
Yes.
probated sentence began after the incident date for what he's pleading guilty to today. So I have advised him that this plea would not, in fact, be a basis for a probation revocation.
Yes. Oh, no wonder he's not here. For what?
He is out of Burnett. He didn't complete the family violence management program for his case in addition to
What was the last thing he hasn't reported? Okay, well, we'll talk about that in a sec. But to your point, Ms. Lake, it looks like the incident date here is August 4, 2021. And so whatever sentence he got out of Gwinnett came after that, in which case there won't be a probation impact for this plea. There may be other issues that we can talk about in a minute, but it's not because of this plea. Okay,
Yes,
got
Your
it.
Honor.
Mr. Mitchell, do you understand that you will be required to obey both the general and special conditions of probation?
Yes, I understand.
Are you entering your plea of guilty with an understanding of everything that we have talked about today?
Yes.
Has anyone used any force, threats, or promises which have caused you to plead guilty against your will?
I understand. Yes.
Do you have any questions for your attorney before we proceed?
No, ma'am.
Understanding all of your rights, how do you wish to enter a plea today to the reduced charge of simple battery family violence?
I will enter the plea of guilty.
And is your plea of guilty made freely and voluntarily?
Yes, it is.
Are you a United States citizen?
Yes, I am.
If you wish to challenge this plea for legal error, you'll have 1 of 2 ways to do so, and your attorney can further advise how each way works. The first way is through a direct appeal, and you'll have 30 days from the date the sentence is entered to file this appeal. The second way is through a habeas corpus petition, and you'll have 12 months from the date the sentence is entered to file this petition. Your Honor, had this case gone to trial, the evidence would show beyond a reasonable doubt that on August the 4th of 2021, officers responded to 6237 Hickory Lane Circle in Fulton County in reference to a domestic dispute. Officers made contact with the victim, Quindarius Smith. Smith advised that while at the residence, he and Mitchell got into a heated verbal altercation that began while traveling in a car. Upon arrival to the residence, Smith stated that the altercation turned physical, which led to the defendant placing one hand around his neck, lifting him off the floor. Smith then stated that the defendant placed 2 hands around his neck and threw him on the bed. The defendant then got on top of Smith with both hands around his neck, causing him to have difficulty breathing. Officers also made contact with the defendant in this case. The defendant stated that he did get into a physical altercation with Smith. However, he said that he also had bruises and scratches on his body. Officers did observe a small scratch on the defendant's upper left arm. Your Honor, the state made this recommendation after speaking with the victim. This victim is currently incarcerated at the Fulton County Jail on an aggravated assault case completely unrelated to this defendant in this case. The victim is in agreement with this recommendation and also due to the age of the case. And so far, he's had no other further trouble with this same victim since then. That's all from the state, Your Honor.
So, Smith is in jail now. The way this sentence is structured, Mr. Mitchell can have contact with Smith again in the future after FVIP is done.
Yes, Your Honor. It was initially no contact. Defense counsel did request contact. The state agreed to contact after FVIP is completed.
Okay. So if they want to restart a relationship, they're free to do that after the family violence intervention program is complete.
Yes, Your Honor.
Okay. Got it. Ms. Lake?
Your Honor, we simply ask you to accept the plea as negotiated. And Your Honor, we would ask the court to waive the supervision fees for misdemeanor probation. He is already on felony probation and subject to reporting fees for felony probation. In addition, I'm sure the court's aware that the family violence intervention program is not free. And so we would like for him to be able to focus his resources on completing that. He's not here in court today because he does have trouble with transportation. So, Your Honor, resources are limited.
Okay. Mr. Mitchell, are you working?
No, sir, I am currently not. I've been trying to find a job and do this on my background. It stopped me from getting at least 5 to 6 job offers that I had, but passed everything. But because this was on my background, that's been the reason I've been having trouble getting the jobs.
Okay. What are you on probation for out of Gwinnett?
It's multiple simple batteries. One was just breaking up 2 exes from getting in a fight, and another one was just speaking, which is simple battery, me saying something out of my mouth, which they gave me simple battery for.
Were you supposed to do the family violence intervention program up in Gwinnett?
I did that when I was on, I did all of that when I was on probation. When I transferred it to Fulton County, I did the whole thing. They said I didn't need to do all of that anymore, but my probation officers and all of that stated that I had to redo it because it was court ordered again for me to redo it. But my lawyer and everything from Gwinnett said that I didn't have to redo anything. So I've been trying to get in contact with my lawyers and everything to further look into all of that, because the judge and my lawyer both said to show them proof that I did it. And I showed them proof, and they keep trying to say that I have to redo it. And they understand what I'm going through.
Okay. Well, if you have completed the family violence intervention program through one of your Gwinnett cases, I'm not going to make you do it again, but you'll need to have, I don't know what they give you at the end, a certificate or what, but I was under the impression you didn't successfully complete it when you were in Gwinnett. So if you can get proof of completion, then you're not going to need to do it a second time here in Fulton.
Okay.
You may be a little sideways with probation right now. I'm hearing that you've been hard to find and that they think you didn't do the family violence intervention program. So you may want to connect with the felony probation pretty soon.
Yes, I've already been in contact with her. And I understand, I've been talking to them because currently I've been homeless due to all of this situation. So it's been kind of hard for me to get around, from me having to stay at one friend's house, which is maybe all the way in Riverdale. And then they tell me, oh, I have to hurry up and report by tomorrow. Since I composed to her to report by tomorrow, when if I'm in Riverdale and y'all giving me not even 48 hours notice to report all the way to Lawrenceville to report, which is kind of far. And
okay.
The train doesn't even go all the way that far.
Got it. All right. Mr. Mitchell, how long have you known Mr. Smith?
5, 6, 7 years.
Okay. You understand that you guys are taking a break till we clear up whether you finish the family violence intervention program? Tough timing for him to freeze up.
No.
While he's frozen, Ms. Lake, can someone in my office or in Judge Ingram's office sign the indictment for you?
Yes, Your Honor.
Ms. Washington?
Yes, Your Honor.
Okay.
Yes, sir, I understand.
Okay, good to know. Hey, Mr. Mitchell, is it okay if someone from my office signs the indictment for you? Mr. Mitchell?
Yes, can you hear? I'm sorry.
Yep, we can hear
Hello?
you now. Is it okay if we sign the indictment for you?
Yes, sir.
Okay. Mr. Mitchell, I find there's a factual basis for your plea. Your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter the plea. I'm sentencing you to the reduced charge of simple battery, family violence to 12 months probation. I'm waiving your probation fees. You will need to complete the family violence intervention program or provide proof that you've already done so, and no contact with Mr. Smith until you have completed or provided proof of completion of the family violence intervention program. Any questions about any of that?
No, sir.
Okay, it looks like someone from JCS is on. Do they chat with him now or what?
Yes, we typically put them in the breakout room so that they can sign them up.
They can chat? Okay. I'm gonna move you and your lawyer? Well, you don't have a phone, but yeah, I can't move you, so,
I can hop on the Zoom.
okay, you wanna do that?
Yes, thank you.
Okay. I'm gonna put you and Ms. Lake in a breakout room, Mr. Mitchell, so you can talk with the probation folks about signing up for misdemeanor probation, okay?
Can I ask you a question first? Do you want him to enroll within the program within a certain amount of days?
Yeah, why don't we do that? I'm gonna give you 30 days, Mr. Mitchell, to have enrolled in the Family Violence Intervention Program if you haven't already completed it, okay?
Okay, not a problem.
Good. All right. Anything else, Ms. Washington?
No, Your Honor.
All right.
Thank you, Judge. And Your Honor, can I please be excused?
You sure can.
Thank you.
They disappeared. The JCS person dropped off. Oh, no, it's there. It is. JCS.
No, oh, right here.
You're still here. I missed you. It's good. And then we're just waiting for Ms. Lake to join in. All right. Ms. Wood, we're gonna do Javon Redmond next, if that's okay. Okay.
Judge, we want to convene on this guy. No.
Oh, if you all have finished talking, we can close that out. Let me just get Ms. Lake in. Mr. Redmond, can you turn your camera on, please? There you go. All right, you got what you needed?
Yes, thanks, Judge.
Sure. All right, they'll figure out how to get him in there. Yes, I think so. You get out? I'll get you out if you need it. Okay. Sure. All right, before we start with Mr. Redmond, let me get Ms. Scott back on the record. Ms. Rios, did you and Ms. Scott have an opportunity to talk about her options? Okay, and what is it that she wants to do?
For the plea, we would be asking for at least 2 weeks for her to get her.
Well, that's a reasonable request. Let me see. Would Monday, June 2 be enough? That's more than 2 weeks. I'm just trying to pick a time. Okay, so Ms. Scott, here's how this works. You will need to be here by 9 a.m., this courtroom, on June 2. And if you are, the sentence is exactly what I described. If you are not here at that time on that day, then I will impose a sentence that involves 3 years to serve rather than 6 months. So you will have, whatever that is, grown your sentence by a factor of 6. I don't actually have concerns that you're going to disappear, but if something comes up and it is difficult to get here by that time, traffic, kid gets sick, whatever it is, let Ms. Rios know so she can let me know. And if I'm persuaded that, yeah, she's going to be here at 10 or 11 or the next day, then we keep the sentence as what I discussed. But this is the plea that you are accepting now. And so that will be your sentence when you come in. We actually won't have a hearing. I'm going to be in court at that time, but you'll come in, don't bring anything complicated with you, dress real plainly, and Deputy Gordon will just take you straight into custody. You will get credit. I think you were in for 4 or 5 days, however long you were in when you were first arrested. Okay, however much it was, you'll get credit for all of that as well. Okay. Ms. Rios, anything else we need to cover?
Bench warrant.
Yeah, I thought we set that aside. Did I not set that aside yet?
I didn't see it being set aside, but maybe I'll double check because I didn't want her to get arrested in those 2 weeks.
I don't either. I'll make sure Ms. Nelson and I will work through that so that the bench warrant gets set aside. This is the one that was a byproduct of Ms. Scott being in Clayton?
Yeah.
Okay. Yep, we'll take care of that. Okay. Ms. Clark, anything else in the Scott case?
No, you're right.
Okay. Ms. Rios?
No, you're right.
Ms. Scott?
I'll make my. If my kids go into state custody, will I be able to?
You certainly will. I don't do a lot of that kind of stuff, but once you are out of custody, they're your kids. They're not someone else's kids. And they'll work through all that with you. My goal was to disrupt that as little as possible. I know this isn't a simple decision to make, but that's the balance that I tried to strike. But Ms. Rios doesn't practice that kind of law either, but she can give you some thoughts about how that process works.
Just really try to avoid it.
Okay. All right. I will see you then June 2 at 9 a.m. Okay?
Yes.
All right. Thank you, Ms. Rios. All right, let's turn to Mr. Redmond, please. All right, Mr. Redmond, can you hear me?
Yeah, I can hear you.
Great. Mr. Redmond, you are here because Ms. Adams said you are prepared to enter a plea. Is that correct?
Correct.
Okay. You are appearing virtually in case 24 SC 005674, as is your lawyer, as is the prosecutor. And that's fine, but I need you to tell me, Mr. Redmond, that you are waiving your right to appear here in open court. Mr. Redmond, you froze up on us. There you are.
Okay, I can hear you again. I'm sorry about that.
Were you able to hear what I said? All right, let's try again. I hope you've got a good connection.
Partially, okay, if it doesn't work, I'm gonna switch to my phone instead of this Wi-Fi connection.
All right, you want to switch to your phone?
It's going in and out again. Give me a second. I'm gonna switch to my phone.
Okay.
Yeah, give me 1 second. Morning. Hello?
Yep. Can you hear me?
Yep, I can hear you.
All right. Let's try again. So, Mr. Redmond, we're here to take a plea in your case. Before we can get started, I need you to tell me that you are waiving your right to be here in open court and you're okay appearing virtually.
Yes, I am.
Okay. Your lawyer, Ms. Adams, is appearing virtually as well, but she is not where you are. She's somewhere else. Are you waiving your right to have your lawyer by your side?
It looks like he froze up again.
Yeah, Mr. Redmond, this isn't going to work.
He may have to
Trying to
step
disconnect
outside.
from my laptop.
What? I thought you were going to use your phone.
Our apologies, Your Honor.
That's okay. He's still on, and maybe that's his phone. He just needs to turn the video on.
Right.
Mr. Redmond, you there?
Yeah, does it still seem choppy?
Well, no, I can hear you a lot better. Let me see. We need to turn your video on.
Yeah. You see how to turn the video on? Okay. Okay.
There we go.
Is that good?
I think so. Let's see. Let me add you. Oop. There you are. Okay. Can you hear us?
Yep, I can hear you.
Good. All right. Stay there. Don't go anywhere. So, Mr. Redmond, I think we've established that you are okay appearing virtually, not here in court, and you are okay appearing with your lawyer not at your side. Is that correct?
Correct.
All right. If at any point you want to speak privately with Ms. Adams, let me know and I'll put you guys in a breakout room. All right?
Okay, no problem.
All right. Ms. Dilligard, when you're ready.
Mr. Redmond, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct legal name for the record.
Javon Redmond.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 32. I graduated from college.
Where'd you go to college?
Full Sail University.
What was the name of the school?
It's called Full Sail University.
How do you spell that?
FULLSAIL University.
Where's that?
It's down like near Orlando. It's called Winter Park, Florida.
All right.
Mr. Redmond, do you understand that you've been charged with the following offenses? It's 2 counts of aggravated assault and 1 count of possession of a firearm during the commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
I was told it was only 2 charges. I'm sorry.
Yeah, I'm just going over what you've been charged with in the indictment.
Okay. Copy. Yes, I understand.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charges?
Yes.
Do you need any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes, I am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Mr. Redmond, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? Through negotiations, we have agreed to reduce counts 1 and 2, the aggravated assaults, to reckless conduct. The range and to null pros count 3, my apologies. The ranges for reckless conduct is 1 day to 12 months. Do you understand that?
Yes.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. The state is recommending a reduction on counts 1 and 2 to reckless conduct and pursuant to OCGA 16560, a null pros on count 3, the possession of a firearm during commission of a felony, for a sentence of 12 months of probation. That your understanding of the recommendation?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
Do you understand that the court decides to order a sentence that differs from the negotiated plea that you were expecting, then you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you are not allowed to possess or use a firearm?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal a convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes.
Mr. Redmond, how do you plead to the reduced charges, 2 counts of reckless conduct in indictment number 24 SC 005674?
Guilty with offer.
Are you pleading guilty under Alford because you've decided that it's in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, that this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a misdemeanor charge, you have 12 months from today to file that petition?
Yes.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on October 28th of 2023, officers with APD responded to 732 Vinson Place in reference to a person armed and injured. When they approached the residence, officers heard a male yelling and stating that he was going to kill me. Officers looked through the glass storm door and observed a male lying on the floor with a pool of blood around his head. That was later to be determined to be the defendant before you. He has sustained injuries. After speaking with the victim stated that him and Mr. Redmond, who had been really close friends for numerous years, were in the kitchen. They had been drinking a lot all day, both parties. The victim stated that they both fell asleep at the kitchen table. The victim was then awakened by the feeling of a firearm on his head. They then had a verbal altercation, and the victim pleaded with the defendant to put the firearm away. The victim's wife heard some of the dispute and entered the kitchen. The defendant then turned the firearm towards the wife. At that time, the victim in this case grabbed the glass table and threw it at the defendant, which caused his injuries to his head. The recommendation is as after speaking with the victim who didn't want to pursue any charges at all, both parties were extremely inebriated at the time. The sequence of events is not super clear after speaking with counsel. We've really tried hard to figure out from both parties what exactly occurred and why. However, it is clear from speaking with the victim that there was a firearm pointed both at him and his wife, which did cause an altercation to occur, which did result in injuries to the defendant. Not aware of any previous violent history from this defendant. I believe was his second arrest, the first being a DUI. I did speak with the victim prior to this hearing, and he did not wish to attend.
Okay, thank you. Good morning, Ms. Jackson. How are you?
It's Miss Adams. Good morning, Judge. How are you?
I'm talking to Ms. Jackson. Then I'll get to you, Ms. Adams. Hey, Ms. Jackson.
Good morning, Your Honor.
Good morning. What criminal history info do you have for Mr. Redmond?
He has 2 cycles. The last arrest was April the 30th, 2016 with the City of Atlanta Police Department for a DUI. There was no disposition for that arrest. Nothing in addition, Your Honor.
Thank you. Now, Ms. Adams, your turn.
My apologies, Your Honor.
That's okay.
As you've heard, this is Mr. Redmond's second arrest. And as Ms. Dilligard stated, we don't still to this day know what happened. The investigation starts with the police arriving to the home and my client is lying on the floor in a pool of blood. They think that he is not going to make it. He's taken to Grady. I visited him there. He had very severe injuries. He has a permanent brain injury. He wasn't able to close his mouth. They had to do several surgeries on him while right after the incident and days after he was released from Fulton County. He had to return for additional treatment. He's since recovered and returned back to working. He is he works in the film crew of several shows that are filmed in Atlanta. He's actually working on set now for one as we are doing this plea. And so we would like a part of the probation to allow him to travel in times that his job does allow him to travel for work, that he be able to do that. This is just how the best resolution we could come to in this situation. I mean, we honestly can't speak to anything. My client doesn't remember anything. We have tracked back messages and videos in his phone, and the latest time that we can go back is to midnight. And so we don't have anything to add to the situation or to dispute what is being said by the other two people present. And so that is the reason we're entering this offer plea today, and we'd like your honor to accept the recommendation as presented by the DA.
And did I understand, Ms. Dilligard, correctly that your client got hit with a table? It was a glass something that was thrown at him. I thought she said table. Is that what it was?
We believe so. That's what it appeared to be by the scene. I mean, there was blood on the floor. There was blood on the walls. It was disturbing to see, but that's what he said he picked up to hit him with, after allegedly my client points this gun at him and his wife and pulls the trigger, is what the story is being told. But I mean, there was a weapon there. We have video that shows that, both parties were looking at this weapon. There was talk about the victim wanting to sell the weapon to my client. So I mean, there was a weapon on scene. My client did come with a weapon, but yeah.
Okay. And when you mentioned travel with work, is travel in Georgia? Is it out of Georgia? Is it out of the U.S.?
I don't believe it's out of the U.S. Javon can chime in. Is it sometimes out of the U.S.? Oh, well, I guess if the show goes on a trip.
Planned to Portugal.
Yeah, so international travel is a little more complicated than domestic travel.
It'll only be about 4 or 5 days.
So he's on misdemeanor probation. I don't know if that changes that
Right.
difficulty.
When you travel, Mr. Redmond, with work, they pay for everything, or do you have to buy the tickets?
Oh, no, I don't pay for anything at all.
Okay, well, that'll make it easier because then it'll be easy for you to document it. Okay, I think I can address that. Ms. Dilligard, did you have any conditions of probation? I didn't have anything written down.
Judge, I do not. There was no conditions that were negotiated.
No stay away from the guy, the table thrower, or his wife?
I asked the victim and he did not wish for me to include that in the resolution.
Okay.
My client has those stayed away, Your Honor. He hasn't had any contact with him since the incident. So
okay, I can understand that. So, Mr. Redmond, you have no recollection of what the beef was between you and your friend?
I have recollection of that night. I have no recollection of anything negative.
Okay. All right. Do you have any questions or anything you want to add, Mr. Redmond?
I don't believe so.
Well, I find there's a factual basis for a plea to reckless conduct, 2 counts, and that your plea is knowing and voluntary. So I will accept it. Ms. Adams, can someone in my office sign the indictment on your behalf?
yes, Your Honor.
Ms. Dilligard?
Yes, Judge.
Mr. Redmond, is it okay if we sign the indictment for you?
It is, yes.
All right, we'll do that. So I'm sentencing you to 12 months on count 1, which has been reduced to reckless conduct, 12 months on count 2, similarly reduced. Count 3 has been dismissed by the state, so it's a total sentence of 12 months probation. I will have indicated on your probation that as long as you are seeking permission in advance and you can document it that it's work-related travel, it's okay for you to travel outside of Georgia and even outside of the United States, as long as those travels are less than 2 weeks at a time. Is that a fair window?
Yeah, I appreciate that.
Okay, but again, you'll need to let probation know before you go, hey, here's my itinerary, I'm leaving next week, and they'll be all right with that, okay?
Got it. Yep.
All right. Well, if you all don't have anything else, I noticed that misdemeanor probation has stayed on this call. And so my thought is to put Ms. Adams and Mr. Redmond into a breakout room with Ms. Nyasha from JCS. And that way you can get your reporting instructions, Mr. Redmond. You okay?
Yep.
All right. So
sorry, just wanted to ensure that it was a sentence under offered.
oh, I hadn't heard that, but that's fine. Do you have any objection to it being an Alford plea, Ms. Dilligard?
No objection, Judge.
Okay. done. That will be reflected on the plea that it was on the final disposition, that it was an Alford plea.
Thank
Okay?
you.
All right, I'm gonna move the three of you into a breakout room and we'll see what happens.
Thank you, Your Honor.
You bet. Okay, they're all in there. Gomez, we have a sheriff's deputy on the call who's anxious to, I don't know if he's up. Are we moving forward with Gomez this morning? Okay. Is that a Ms. Dilligard case?
Yes, Judge.
Okay.
And I think she's going to rope in that other case. Yes, two cases.
Okay. I'm gonna, I've got this right here. So yes, there's a 25 SC. So we'll talk about both those. Can we bring Gomez out then, please?
It's normal here. Judge McBurney, your son graduates, right?
On Sunday.
Okay, congratulations.
Thank you. Exciting times.
I'd be somewhere crying. Is he gonna play baseball in college?
He is.
Okay, where's he going?
He's going to Brown.
Oh, wow.
Up in Providence, Rhode Island. He's going to be a Brown Bear. Yep. He's very excited. He's playing in a collegiate league this summer in the Southeast. And then he goes up in the fall, starts there.
You should be very proud. I know you are.
Well, assuming he graduates on Sunday, I'll be very proud. He had his last AP exam yesterday, so he's done. He should, absent getting arrested or something, he should be fine for Sunday.
My daughter is in 8th grade. She had her honors ceremony yesterday. Now she thinks she shouldn't go back for any. She's like, I got the flowers and the balloon. I don't understand why I'm going back.
All right, why are you doing this to me?
She doesn't want that.
Hey, Mr. Gomez.
How you doing?
I'm doing all right. It's good to see you.
Good morning.
Ms. Rivers, are you good if we do another plea?
Yes, I am. I can't
Great.
believe 8th grade, Miss Cabrera.
That's right. 8th grade. She's going to high school. So it's over.
All right. Well, let's turn to Mr. Gomez's cases. I have on the calendar 24 SC 002 021. There is a more recent case, a 25 SC 001 688. Is it your understanding, Ms. Cabrera, that whatever we do today is resolving both those?
That's my understanding.
Then we'll work through both those. Mr. Gomez is here in court with his lawyer. Ms. Dilligard, the prosecutor, is here. I'm gonna put her on the screen and let's get the podium on the screen. Now everyone can see everyone. I guess, Ms. Dilligard, you'll explain. We've got a sheriff's deputy, Richardson. Is that going to be a witness at some point?
Judge, that's the victim in the case.
Okay. In the aggravated assault or the more recent one? Or maybe they're both aggravated assaults?
In the aggravated assault case.
Okay, excellent. Well, I appreciate his patience. So, Mr. Gomez, here's the plan. In just a moment, Ms. Dilligard, who's on the screen there, is going to put you under oath, and she's going to ask you some questions. You need to answer the questions to the best of your ability. If any of the questions don't make sense, let Ms. Cabrera or me know, and we'll help you through that. And then after I've heard from the prosecutor, I'll hear from your lawyer. And then if there's anything you want to add, I'll hear from you as well, okay? And then we'll figure out what we're going to do. Ms. Dilligard?
Mr. Gomez, can you please raise your right hand to the best of your ability?
I'm going close to that.
Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Can you please state your true, correct legal name for the record?
Stephen Gomez.
Mr. Gomez, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you've not taken today?
No.
How old are you and how far have you gone in school?
I'm 36 and I graduated high school.
Where'd you go to high school, Mr. Gomez?
I went to high school in Boston, Massachusetts.
Okay, what was the name of the high school?
Charlestown.
Mr. Gomez, are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses in indictment number 24 SC 002021? It's 1 count of aggravated assault, a count of possession of a dangerous weapon by an inmate, and obstruction of law enforcement officer. And then in 25 SC 001688, it's 1 count of obstruction of law enforcement with human bodily fluids.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the charges in this indictment, including the facts and circumstances related to the charges?
Yes, I have.
Would you like any more time to discuss these cases with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes, I am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
So waived.
Judge, I'm not aware of any outstanding warrants related to any of these charges.
Okay.
Mr. Gomez, has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For count 1, the range is 10 to 20 years. For the indictment ending in 2021, my apologies. The aggravated assault due to the victim being law enforcement, the range is 10 to 20 years. On count 2, the range is 1 to 5 years. And on count 3, the range is also 1 to 5 years. And then on the obstruction in indictment ending in 1688, that range is also 1 to 5 years.
Yes.
Do you understand that your pleading guilty today is called a non-negotiated plea, and that the state may recommend a sentence to the court even without having you agree to it in advance?
Yes.
Are you aware that the state's offer in this case is a global resolution for both cases for a sentence of 25 to serve 20?
Yes.
It had gone to 18. Does that change for the purposes of this plea?
No, I'm comfortable with the 18.
Okay.
So the offer is 25 years to serve 18 years in custody.
This is the state's this is a non-negotiated, so this is the
It is.
state's recommendation. Okay.
Have you discussed this offer with your attorney, Mr. Gomez?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, and a plea is given, that a plea is ordered in by the court, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Are you currently on probation or parole anywhere?
Probation.
I'm on probation, yes.
Do you understand that if you're currently on probation or parole, your probation and parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, to include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Gomez, how do you plead to the charges of aggravated assault, possession of a dangerous weapon or by an inmate, and obstruction of a law enforcement officer, and indictment number 24 SC 002021?
Guilty.
And how do you plead to the charge of obstruction of law enforcement with human bodily fluids and indictment number 25 SC 001688?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes.
Judge, if these cases were to proceed to trial, I'm going to start with the aggravated assault case. It's the state's understanding that this defendant was in the jail due to an aggravated assault that occurred on November 8th of 2020, where he stabbed a victim with a knife. He pled guilty to that case on April 10th of 2023 and received a sentence of 5 years to serve 2. While in the jail, and I'm just going to kind of going in chronological order, on July 27th of 2021, there was another incident that occurred. This is his conviction under 22 SC 180418, which he pled guilty also on that same date, April 10th of 2023. This incident happened, he assaulted a detention officer with a handcuff that was on his wrist, and that detention officer received some injuries to her face when he swung it towards her head. That brings us to the aggravated assault and indictment ending in 2021. The state contends that the evidence would show that on April 7th of 2022, Investigator Kettle was investigating an incident that occurred between Mr. Gomez and Detention Officer Richardson, who is on the call with us today. While Mr. Richardson was going around distributing food trays, this defendant then jumped on his back, attacked him from behind, and stabbed him multiple times. He had injuries to his head, his left calf, and both arms. He had to be transported to Grady to be treated for his injuries. There wasn't another inmate that we've had contact with as preparing this case for trial, who was the inmate who was able to get Mr. Gomez off of the victim's back, and they were able to detain him at that time. A shank was recovered from the defendant that was utilized in this incident. And I do have the victim on for this case if you would prefer to hear from him now, or if you would like to hear the factual basis for the other case.
Why don't you go through both, and when you're done, then I'll turn to D.O. Richardson.
Okay. So the next incident for the indictment ending in 1688, this occurred on June 14th of 2022, while Deputy Skyers was on guard at the Fulton County Jail. And Mr. Gomez threw a cup of bodily fluids at him as he passed his cell. The fluid landed on the back of the officer's uniform, which contained both urine and feces. The defendant threw the cup while his door was cracked open, and Tao was able to make contact with the deputy in that case. I do want to add, for, and apologies to go back, for the aggravated assault. Mr. Gomez did state that he made a statement that he said that he was going to get himself an officer, and that's why that incident occurred. And I believe that's everything that I have to offer. I do want to add, when reviewing his criminal history, I did see 2 arrests from Massachusetts. I'm unclear of the dispositions in those cases. There was a 2009 armed assault with intent to murder out of Plymouth County arrest. And then there was also an arrest in 2006 for armed robbery out of Norfolk County. I don't see any convictions out of Georgia. That's all.
All right. Thank you, Ms. Dilligard. Deputy Richardson, if you would unmute, please. I'd like to hear how you are doing and what kind of impact this has had on your life, your career.
Can you hear me, Judge McBurney?
Yes, sir, I can. I can see you too.
I'm doing good, Judge, but I did have to take some time, you know what I'm saying, to reevaluate some things when that incident occurred, because that was uncalled for. So I did have to take some time off to see if I want to stay in law enforcement or not, Judge.
Were you in the hospital for very long? How long were you out of service?
I was out for about a month and a half. I wasn't in the hospital long, but
yeah,
I had to take some time mentally, you know.
Sure, no doubt. Apart from the emotional impact of this, is there lingering physical damage? Are you able to move around as you did before?
Oh yes, I'm fine, Judge. I just thought that day, I thought I was going to lose my life. I was fighting for my life that day.
Yeah. Okay. Well, no one should have to go through that. I'm glad that you made it. We're glad that you stayed with us, and I appreciate you being here. Anything more you want to add?
No, that's all, Judge.
Okay. And tell me what your role is now. Are you still a DO or what do you do?
I'm still a DO, but I'm in the courts division now. I work in the jail courts division now.
Okay. Well, good. Well, thanks for staying with the team. Appreciate it. I'm glad you're doing okay.
Thanks, Judge.
All right. Hang in there. All right. Ms. Cabrera.
Yes, Judge. As he said, he's 36 years old. He did graduate high school. He has 2 children, ages 3 and 7. He's been in custody for, I think, 4 years and 3 or 4 months. Obviously not for all of this. He goes into custody for a completely different reason. And then both of these cases happen while he's in custody. So we'll have different credit times, which he understands. He was not interested in taking this to trial. He was interested in resolving this and accepting responsibility for it. In that it's a non-negotiated, I would be asking for 25 to serve 10. If Your Honor remember, we had to do some evaluations. There were some things that had to be done. He came back competent to stand trial, but that has nothing to do, or it doesn't speak to what his mental state may have been at the time of anything. When he went into custody, he's schizophrenic. When he did go into custody, he was not on any medication. He's actually only been back on the medication somewhere in the last year. And so he's taking it now, which is why I wanted us to go on ahead and address this. While it seems that he is of clearest mind, that he has the best understanding of what's going on, and he seems to be on the right track as far as taking medication there. He is in counseling while he's in custody. He's, I guess, there's a mental health unit. And so he's a part of that mental health unit. And so that seems to be working for him. Since he's been in custody, he also had to do a stint at Georgia Regional for a little while. So it's been interesting ride for him, to say the least.
Right.
But I think right now he's at least in a far better posture. So I believe he understands what's happening. The request for the 10 years to serve wasn't even my request. It was his request. I asked him flat out, what would you like me to ask the
Right.
court?
What's a reasonable number? And that's what he came up with.
Yeah. And so that, if nothing else, to me shows that he definitely has some awareness, definite awareness of the situation. I don't think that 10 years is something to sneeze at, right? He could have said, like many others would have said, well, give me credit for all the time that I've
Right.
served.
I've been
and
at
put me
Rice
on
Street for
probation.
3 years. That's worth 1,000 years.
Correct.
Yeah.
But he didn't do that. So I'd like for Your Honor to consider that as a resolution for him. He's currently, there shouldn't be a probation violation at all. Because the probation that he would be on right now is for the case that he was first in custody for.
Okay. All right. And is there anything left, or Mr. Gomez can go to the Department of Corrections
He can go to the
as a
Department.
result of today's dispositions?
Right, so since we're doing both of the cases, he should be able to go to Department of Corrections.
Okay, good. All right. Mr. Gomez, you have 2 kids, boys or girls?
2 girls.
2 girls. One of them must be a little older than 3. If you've been in jail for 4 years and some months, the youngest one must be a little older than 3. Okay. Tell me, how'd you get down here? You grew up in the Boston area.
I grew up in the Boston area, and I was working with somebody from a TV show called Love and Hip Hop named Ray Benzino. And I was dealing with the music industry business down here. I had a recording studio, recording label on the west end of Atlanta, about Western Station.
Got it. And that got you down here.
Yes.
So one of the things Ms. Dilligard asked you is whether you're taking any medication, and I think you told her no, but Ms. Cabrera said you are taking medication. I just want to make sure I'm clear. It sounds like you are to help with the schizophrenia. Is that correct?
Yes.
How long have you been taking that?
I've been on it since last, I would say June of last year.
Okay, so almost a year now.
Yeah.
Good. Does it help?
Yes, it does.
How often do you take it?
I take it, I take a shot once a month.
Yeah.
I get a shot of Winnebago once a month. And I take pills, 4 different pills every day, every night.
At night, you take the pills?
At night, I take pills.
Did you get the pills last night?
Yes.
Okay. And when was your last shot?
My last shot was just last 28th of the last month, the 28th of April.
So you're coming up on your maybe another week or so, you'll get your next shot.
Yes.
Okay. The pills that you take at night, do they make you drowsy or woozy or anything?
They help me sleep. They help me with voices.
Okay.
They help me with delusional thoughts that I have.
Got it. When you wake up in the morning though, are you usually pretty clear-headed after a good night's sleep?
Yeah, I'm pretty much clear-headed.
Okay,
It's been helping
good.
a lot.
So you're understanding what we're talking about today.
Yes, I am.
Is your plan when you get out, because you will get out at some point, to stay in Georgia, to go back to Massachusetts?
Depending on how the probation is, I don't know if the probation will let me leave right away.
They won't let you leave right away. You can get your probation transferred. You have to fill out some paperwork, and it takes a few weeks for all that to get approved.
Right.
But would your plan be to go back to Massachusetts or go somewhere else?
My plan would be to be with my kids.
Where are they?
They're both in New York right now.
New York.
Yeah.
Do they have the same mom or different moms?
Same mother.
Okay. New York is in New York City?
New York City.
Okay. Are you in touch with her?
I'm in touch with her, yes.
Okay. And she would be okay having you around?
Yes.
Okay. All right. Do you have questions about anything?
No.
All right. Well, Mr. Gomez, I find there's a factual basis for both your pleas in that your pleas are knowing and voluntary. Knowing means you've understood what we've been talking about.
Yeah.
And you told me you don't have any more questions. Voluntary means no one's forcing you to enter this plea. You've decided it's in your best interest to plead rather than go to trial. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you are on probation, if you have a small problem, you and probation can sort that out. You don't have to see me. But if it's serious, if you get arrested again for something, that comes back to me and we'll figure out what the consequences are. Ms. Cabrera, can someone in my office sign the indictments, plural, for you?
Yes.
Ms. Dilligard?
Yes, Judge.
Great. I gotta check one thing. Mr. Gomez, is it okay if someone in my office signs the indictments for you indicating your pleas?
Yes.
You waived any defects in the indictment, Ms. Cabrera? There's a date defect in the case ending in 021. two of the counts indicate that the incident was on April 7, 2022. And then the third, it's all the same thing, but the third one, the obstruction, it says April 7th, 2023, but we're talking about the same incident? Okay, good. I have to correct one thing. I believe, this was news to me, I didn't realize that aggravated assault on law enforcement had a higher mandatory minimum.
Right.
But the 10 to 20 range is if a firearm was used, and this wasn't a firearm. So the range is actually 5 to 20. It's not going to change what's happening here, but I just want the record to be clear that that carries a mandatory minimum of 3 years to serve. And the sentence, it has to be 5 or more. 5 to 20 is the range, but everything else is as is. All right, Mr. Gomez, I am going to sentence you as follows. In the case ending in 021, on count 1, I'm going to sentence you to 13 years to serve. Count 2, I'm going to sentence you to 5 years to serve, but that's going to be consecutive and not to serve, but on probation. Let me be clear. Count 1 is 13 years to serve. Count 2 is 5 years probated consecutive. Count 3 is 5 years probated concurrent with count 2. So that total sentence is 18 years to serve 13 years with a balance on probation. And you'll get credit for time served since April 7th of 2022. So you're already 3 years plus into that sentence. And your sentence in the case 25 SC 001688 will be 5 years to serve. That'll run concurrently with your sentence in the case ending in 021. So to repeat, so you're not, I garbled it a bit when I was saying it. Your overall sentence, when you combine all this together, is 18 years to serve, 13 years with the balance on probation. So 5 years probation. You'll be eligible for parole. I don't know when you'll be paroled, but that's something you and folks at the Department of Corrections can talk about, okay? Ms. Dilligard, anything else on behalf of the state?
Nothing further, Judge. Thank you.
Okay. Ms. Cabrera, anything else?
Nothing further. You have any questions?
No? Okay. Thank you again, D.L. Richardson. Appreciate your time.
Thanks, Judge.
All right. Good luck, Mr. Gomez.
Thank you.
Yes, you could have been excused before. You don't have to ask if you don't have anything more. So you're free to go. Are we going to do Jintown? Great. I need 2 minutes to just go get the trial calendar. Ms. Dilligard, before you go, let's just talk the three of us, Wood, Dilligard, and McBurney. What's it looking like we're going to do on Monday? We won't do Jintao. That's going to be a plea. Sort of surprised based on what I heard about what was on the cell phone that Ferguson hasn't gone away. But that's listed first for the calendar next week.
It's going away, Judge.
Okay,
I talked
just
to,
not today.
Deputy Besa and Ms. Charles, and yes, that's going away.
Okay, going away as in away, no plea, or it's a plea?
Oh,
Okay, and they'll make that announcement, I guess, Monday morning.
I talked to Ms. Charles, she's out of the country.
Oh.
She was working to get the order in because I was gonna ask if Mr. Ferguson could be dismissed or excused.
Excused. Let's say if you have it on good word from either or both of them, then let's have Mr. Ferguson not show up. Okay?
And
That gets us to Gil.
Yes.
Okay.
That one is ready to go.
Okay, and I saw your motion in limine. And is that with Ms. Nix?
Yes.
Okay, all right. And then Ms. Dilligard, you're ready to go. If for some reason Gil falls apart Monday morning, I don't remember which was first, the carjacker guy or, okay. So you'll be ready with that?
Yeah, Judge, I've been talking with Ms. Wood to kind of see where we are in negotiation. And if the case is going to resolve, I likely am going to re-indict to add all of the cases together so that he will be able to utilize his first offender. So I'm kind of in limbo just to hear back from Ms. Wood to see where we stand on Johnson.
Can you do first offender on carjacking? You should check on, I don't know. I know there's some things you can't get first offender for. I don't know if carjacking's in that category, but I'd hate for you to go through all that effort only to be denied by the statutory limit on first offender.
I will double check on that, Judge. And then I also had another point that I brought up with counsel is I believe if we weren't to do a global resolution, when he goes to resolve his newer hijacking, that the range will be up to life. And so that was another reason.
Okay. All right. And then what's the one after that on the list?
Nickerson.
Oh, Nickerson, which is an arm robbery. I don't know anything about it. Okay. It sounds like Gill is going.
It is.
The state had come down a little bit. It wasn't enough for Mr. Gill.
I spoke to Deputy Patel yesterday. It's going.
Okay. He's driving his big old truck here, be here Monday morning?
Yes.
Okay. All right. Ms. Dilligard, I still ask you to come Monday morning, just in case. But it sounds like that'll be a Ms. Nix production instead.
Yes, Judge, I will be there.
All right. Thanks for your time.
Thank you. Have a great weekend.
You too. Bye-bye. All right. Then I will be right back. We'll get Mr. Jin Tao. Hey, Mr. Jin Tao, can you turn your camera on, please? Why don't you try texting him or something? Oh, he turned it on. Great. All right, we're going to get started in just a minute, Mr. Jintao. Thanks for being patient.
I'm going.
Yeah, this was my order of proof, not my PowerPoint, it's not a PowerPoint.
So Lord, please don't let there be a presentation.
Yeah, yeah, because I thought I was going to trial on it, so. For real, I do it for my investigators so they can know, like, to get the witnesses and stuff.
Got it.
Mhm. How's Maryland doing?
is blocking my driveway. She does not live here. Oh, I'm not fighting with you. You gotta find out right there. No, it's not a problem. You don't live over here. You don't live
That's
over
Ms. Rivers's end. What's going on in the Rivers household? Okay. Hey, Ms. Cabrera, you're back already.
I am. I was in court and I forgot to ask about Mender and Williams for their bond orders because Williams family especially, they ask probably every day, twice.
Yep, and they bug Ms. Nelson as well. I had a good conversation with pretrial services yesterday and got an answer that is favorable for both of them. I also was not at work yesterday because my kid and I were sick. But I had that conversation, so I will work on amending the bond orders for both those.
Okay. Should should I tell the family just kind of get through the weekend?
Yes,
Okay. All right. I will definitely tell them that. Get through the weekend and you've worked on something.
yep,
Perfect. All right. Thank you, Judge.
you bet. Take care.
All right. Congratulations. Have a great weekend.
Thank you. All right, Ms. Rivers, can you hear us?
Yes, I can. Sorry about that. That was a video someone sent me.
Whatever. Okay. Just if we need to dial 911, let us know.
Okay.
We lost connectivity for a little bit. The Zoom session had ended because some of these pleas took so long. But we're back up, and I don't think we need to recreate that part for the record. We were just discussing an option that's not an option for Mr. Jintao, but we will go forward with the plea in just a second. Do you need something before we do this?
Was that 5 years?
I didn't know there were counts 3 and 4. I had 3 counts.
Maybe mine printed out an extra one. I can go see.
It was the 13 to serve, and then 5P, 5P on the 2 others.
Okay.
They were concurrent but consecutive to the third, so it was 18 to do 13.
Okay. Thank you.
You bet. Okay. Mr. Jintao, can you hear me? I need you to unmute on your end. There we go. Ooh, this is gonna be complicated. Do you have? He needs to turn the speaker off on his.
I'm texting him, Jen.
Okay. So he muted again.
Judge, I think we're good to go.
All right, let's try again. Mr. Jintao, why don't you unmute? Okay.
Yes, sir.
Okay. Can you hear me?
Yes.
All right. I don't know why we're hearing everything. Do you have more than one device on there?
No.
Okay, so here's what we're gonna do. When you need to answer a question, you should unmute. And when you're done answering, you should mute again.
All right.
So why don't you mute? All right, it's going to take a while. Mr. Jintao, you are joining us because you are prepared to enter a plea in your case. And as I understand it, you're ready to go forward. Mr. Jintao, are you waiving your right to be here in court, and are you agreeing to appear virtually?
Yes.
Good job. Unmute, then mute. Mr. Jintao, are you also waiving your right to have your lawyer, Ms. Wood, by your side?
Yes.
If you ever have a question and need to speak with her privately, let me know by waving your hand or doing something like that, and we will get the two of you into a breakout room, or she can step outside and give you a call on your cell phone, okay?
Okay.
Sounds good. In a moment, Ms. Clark is going to put you under oath. I'm going to get her on the screen. There's Ms. Clark. Whoops, let's make it easier. This one, can you slide over one? He'll be able to see you better that way. Thanks. And there's your lawyer, Ms. Wood, but Ms. Clark's going to put you under oath, and she's going to ask you a bunch of questions. Please answer her questions. If you have questions of your own while we're going through it, let me know and we'll figure that out. Ms. Clark, when you're ready.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You can put your hand down. Please state and spell your correct legal name.
First name Isaiah, Isaiah. Last name Jintao, Jintao. My age is 19.
And what is your middle name?
Andre, Andre.
Are you at this time Sorry. Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
19.
What's the highest level of education or the last grade you completed?
10th grade.
Where did you go to high school?
I was in an alternative school called Hank Aaron's New Beginnings Academy.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, sexual battery, and count 2, simple battery.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you understand the indictment as explained to you by your attorney, Ms. Wood?
Yes, ma'am.
And have you had an opportunity to review your waiver of rights with Ms. Wood?
Yes, ma'am.
And did you understand the rights that you would be waiving as Ms. Wood explained those to you?
Yes, ma'am.
And it's your decision to waive your rights today?
Yes.
Have you had enough time to speak with Ms. Wood about the charges within the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes.
Ms. Wood, do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment for purposes of this plea?
So waived.
Defendant Gentile, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty?
Yes.
The state will put those on the record. The minimum is for sexual battery is 1 year in prison. The max is 5 years in prison. And for count 2, simple battery is a misdemeanor. The minimum is 1 day in jail. The max is 12 months in jail. Do you understand that you are entering a negotiated plea of guilty, which means that the state and defense will jointly recommend to the court the following? For sexual battery, the state's recommendation will be 5 years probation with the special conditions that no further contact with the named victim, Carmen Woods, and defendant must stay away from all MARTA stations. He must not return to Hank Aaron Academy, and defendant is required to register as a sex offender.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you? Oh, excuse me. My apologies. There is count 2 of the indictment. In this case, defendant Gentile, simple battery. The state's recommendation in that case would be 12 months probation to run concurrent with count 1. So is that your understanding of the terms of the negotiation?
Yes, ma'am.
Okay, my apologies. My apologies, Your Honor. Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively, meaning one after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to demand a jury trial?
Yes, ma'am.
Are you currently on probation or parole?
I can't really remember, ma'am.
I don't think he is, Judge.
Okay, we'll find out.
Okay. Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
It's the state's understanding that the defendant does not have any felony convictions. So we'll be asking Ms. Wood and her client whether or not he will be seeking first offender.
Yes, I believe so, Judge.
Okay, so I'll do that part. Defendant Gentile, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty or no contest to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your attorney, Ms. Wood, explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
Yes, ma'am.
You understand that this means that you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 24 SC 004524, how do you plead to the first count, sexual battery?
Guilty.
How do you plead to the second count, simple battery? Simple battery.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes, ma'am.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
At this time, Your Honor, the state will provide a factual basis for the felony plea in this case. This matter would have went to trial. The state would have been able to prove beyond a reasonable doubt that on the incident date of November 14th of 2022 at the incident location of 2020 Lee Street, which is the location for the Lakewood Station Concourse for MARTA. Sorry. The investigators were contacted about a complaint regarding a 13-year-old minor child. The claims raised by the 13-year-old minor child who attended Hank Aaron Academy indicated that the defendant, who was also a student at Hank Aaron Academy and was 17 years of age, did in fact assault her. The two students did not know each other, but knew that they attended the same school. Around 8:30 or 9 a.m., the defendant was at the Lakewood MARTA station with friends. The defendant saw the victim come through the turnstiles, and the defendant approached her. He put his arm around her, hugging her shoulders, and she ducked to try to get him off of her. The defendant then put her in a chokehold type position, and she squirmed to get away from him, and he grabbed her buttocks. He continued to follow her around The victim stated the defendant tried to kiss her and touch her. At one point, she went into a corner and he grabbed her buttocks again. And in the video, it appears he pressed his groin against her buttocks, but she did not disclose that, and it isn't definitive from the video. The child went on to school and reported the assault upon her arrival. The defendant was arrested on November 16, 2022. Following Miranda, he was interviewed and admitted putting the victim in a chokehold position and grabbing her buttocks. He also admitted that he knew she did not want him to do that to her. Your Honor, the state in this case had a prep meeting with the victim and her mother. And so they at one point they were only willing to do, they only wanted the defendant to do some custodial time. They didn't, as part of his sentence. And so, of course, the state's offer did have custodial time as part of that. However, after speaking with them and prepping with them this week, it was very triggering for the victim child in this case to be preparing for trial and as far as, you know, testifying. So they indicated that it would be fine if the defendant only did probation as long as, you know, to avoid, you know, taking the case to trial. Nothing further from the state, Your Honor.
Okay. Ms. Jackson, do you have any criminal history information for Mr. Jin Tao?
Your Honor, he does not have any prior arrests on file.
Thank you so much, and thank you for joining us today. Have a good weekend.
Thank you, you as well.
Ms. Wood.
Thank you, Judge. I think I've made it fairly clear. I wanted this case to go to trial. I think it's a highly triable case. However, I respect that it is Mr. Gentile's decision as to how he resolves his case. And so that's why we're here accepting responsibility. Judge, on the video camera, just to dispute a little bit of Ms. Clark's interpretation. So it's Mr. Gentile and at least two of his other friends. And the victim does appear to be older than 13. And so it's a situation where I'm not sure how familiar the court is with teenagers, but it is, it is a situation where I would describe it as this group of kids horsing around and being dumb. And yes, he definitely violated her personal space and should not have touched her. I disagree with the description that it was a chokehold. Again, I stand by that it was horsing around. And I wanted to put that out there for some context. Again, Mr. Gentile believed that she was older, given some conversations he and his friends had with her. So anyways, Judge, he is accepting responsibility for touching her inappropriately. He's 19, Judge, he's working right now. So he actually got kicked out of Hank Aaron because of this arrest. And he's currently working on getting his GED. He's got tutoring this afternoon. As the court knows, after this arrest in 2022, he was injured in a shooting and now he's paralyzed for the rest of his life. And so that is part of he's wanted to accept responsibility. And then that's why probation is what we were going for, because going into custody in his state would just not be good for anyone, Judge. He does have diagnoses. He's ADHD, he has PTSD, bipolar disorder, and he's also autistic. Again, he wants to resolve the case, Judge. And so I've given him all of my advice. So here we are. I would ask that the court waive fees since he's disabled and sentence him as a first offender.
The shooting he was involved with, was he, as best you can tell, an intended victim, or it was a random bullet, or it was a shootout and he got hit in the shootout?
He was with a group of other teenagers. I don't know who was actually intended. It seems like he was in the Pittsburgh area near where his cousin lives, is the extent of what I know. I don't think he was the intended target, but he definitely got caught up in the gunfire.
Okay. All right. Mr. Gentile, anything you want to add?
No, Your Honor.
How long ago did you get shot?
It's been like a year ago. It happened March 8th.
And you're paralyzed from the waist down, or where is it? Where is it?
The waist down.
Okay. All right, I'm sorry you went through that. All right, Mr. Jintao, I find there's a factual basis for your plea. I did watch your interview with the Detective Burns, whatever his name was, and it does sound like we are getting closer to what is probably a reasonable outcome in this case. You touched a young lady in a way she didn't want to be touched, and that's not okay, but it wasn't more than that. And so I think this is a reasonable outcome, especially since you're going to have to register. So I do find that there's a factual basis. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to plead. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have small problems with probation, you and probation sort that out. But if there are bigger problems, you get arrested or you're ever around Ms. Woods, things like that, that'll come back to me. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Clark?
Yes, Your Honor.
Mr. Jintao, is it okay if someone in my office signs the indictment indicating your guilty plea?
Yes, Your Honor.
Okay. I'm going to sentence you as a first offender. You're eligible for that. And it sounds like this is the first and hopefully last time you get into trouble. It's your only arrest. But we'll see how that plays out. I'm going to follow what has been negotiated, and on count 1, sentence you to 5 years. Count 2 will be 12 months, and those will be probated. They'll run concurrently with each other. Special condition of probation number 1 is that you finish your GED. Sounds like you're well on your way with that. Number 2 is no contact with Ms. Woods or her family. Talk to me about the MARTA situation, Ms. Wood. I'm reluctant to say you can't ride MARTA if he needs it to get around. What I'd be more inclined to do is say Lakewood isn't a station where you should spend time, but maybe it's stay off the trains and ride the buses. I don't know how that works. Maybe he rides MARTA Mobility anyway, and that's different.
Judge, I would, no disrespect to the MARTA Police Department, but I believe this is a gross overreaction on their part. The lifetime ban just seems outrageous. I think that's what they originally put in the police report. I would ask that that be modified. I don't think I'm not sure. I need to double check with him about whether that Lakewood station is the one closest to where he currently lives.
Well, let's find out. Mr. Jintao, do you still ride MARTA? And if so, where do you tend to ride it?
I have a train station that's close, like across the street from me is H.E. Holmes train station. I don't normally go there. I either have like a transporter that takes me, but his service is in within July, and I have to do MARTA Mobility.
Okay, got it. So what I'm going to do, Mr. Jintao, is say that you need to stay away from the Lakewood station. You can take the train through Lakewood, but don't get on or off at Lakewood. But otherwise, you can use MARTA. You do need to stay away from the Hank Aaron Academy, but you shouldn't have any reason to be there. You've aged out of it anyway. I will waive your probation supervision fees. And then finally, you are going to have to register as a sex offender. That will have an impact on what kind of job you can get if you try to work. And it will also impact where you can live while you are on probation. And then you and a lawyer can work through how much after your sentence is over you need to register. But until you are relieved of the registration requirements, you'll have to renew every year on or about your birthday. Ms. Wood, anything else in Mr. Jintao's case?
Judge, I forgot to ask for a behavioral incentive date.
Okay. Ms. Clark, anything from the state? I'm not asking your thoughts about a behavioral incentive date. I'm just wondering if there's anything else you want me to add.
No, Your Honor.
Okay. Mr. Jintao, any questions about anything we've been discussing?
No, Your Honor.
Okay. I'm going to set a behavioral incentive date of May 17th, 2028. That's 3 years from now. What that means is if you have done A-OK on probation, no arrests, you got your GED, stayed out of trouble, all that kind of stuff, then probation can decide to end your sentence early. They may not, but they will be encouraged to do that if everything has been going well after 3 years. You live in Fulton County, Mr. Gentile?
Yes, Your Honor.
Okay. Ms. Simpson, what reporting instructions should we give Mr. Gentile?
Be contacting him within the next 3 business days.
Okay, you have his information?
Yes, Ms. Wilson.
Great. Mr. Gentile, someone from probation will be contacting you in the next few days about how to report and when and how that's going to work out. If it's been a whole week and you haven't heard from them, reach out to Ms. Wood because ultimately it's on you to make sure that you connect with probation. And the last thing you want to start out with is them swearing out a warrant in the first couple of weeks because they couldn't find you, okay?
Yes, Your Honor.
All right, that's it. Thank you, everyone.
Thank you,
Thank
Judge.
you.
What was that?